Good morning, everybody. Happy Tuesday. Welcome to the Courtroom Files Live. Let's get the day started with Judge Simpson, where undoubtedly a whole bunch of bonds are about to continue.
Don't run on me. Yeah, you're on me.
Douglas, this one does have the information that you need. Okay, that was fun. Johnson, how are you today?
Good idea.
Good as I can be. I don't know what that means. Court does call the case of the people versus Rashad Ahmad.
People, Your Honor.
Good morning, Your Honor.
Good morning.
Good morning, Your Honor.
Haitham Al-Qudsi, P number 68565 on behalf of defendant.
Rashad Ahmed.
Your Honor, today's a concept for preliminary examination. At this time, people are unable to count one of the asset, count two be remanded down to district court.
Count one is dismissed of people being unable to proceed. I'll continue the defendant's plea of not guilty as to count two. A pretrial will be set in this matter.
October 27th at 10 a.m. at Judge Washington.
October 27, 2025. What time?
10 a.m.
10 a.m. before Judge Washington.
Thank you, Your Honor.
Thank you, Bond. We'll continue.
Thank you.
Court calls the case People versus Candace Fair.
And on behalf of the people,
Got it.
But I don't see this.
Is Akin really gonna grace us with her presence, or is she?
Your Honor, I will go and see if she's here. I did see her earlier.
Did you?
I did.
Tell her I'm angry. That will not make her go any faster.
I have not heard anything published from those parties today. Mr. Burns and Mr. James.
There's three of them?
Prosecutors.
Oh. So. What, why are you back if you don't have her?
Your Honor, I was
Why
not.
are you back if you don't? You told me you were going to go get her because you saw her.
I
I
was,
told you to go out, gave you specific instructions. You came back in here empty-handed. And now you want to talk to me.
I was thorough in my search. I did not find her.
You were thorough in your search and didn't find her.
I would
So
respectfully,
Akin really has just disappeared.
and I would respectfully ask if the court can pass this matter. I will.
I just
find
called
her.
it, like, well, 10 minutes ago, because you were gone for like 2.
for the record, I also don't see this fair, so I'm not sure if they're even talking to the room.
I could issue a bench warrant for both then, right? Is that what you want me to do, Miss Lynn? No? She's so nice. What?
Kennedy was like.
I know Kennedy does that. Good job, Warren.
Thank you, Your Honor. Appreciate it.
Court calls the case, People versus Mark Cochin.
Your Honor.
You want to know what?
Good morning, Your Honor. I am Shannon Smith on behalf of Mark Cochin, who stands to my right. Can you please state your name for the court?
Mark Cochin.
Your Honor, today, the facts of the preliminary examination of this time of people are unable to proceed.
And Your Honor, based on that, the defense would be asking the court to dismiss this matter.
People being unable to proceed, this case is dismissed as without prejudice. Thank you.
Thank you.
Thank you, Your Honor.
Oh,
Before you yell at her. Or after.
I'm gonna wait for her to sit down and then call her case. It's like, no. What are you handing me?
What?
Just, you know what? To see. Janaza, everything was going fine. Everybody was getting along just fine. And then came you.
My case. What was it me?
Do you have a client? Or are we good? Is this an excuse? I think that's a yes or no. It's really simple, Janaza.
Good morning, Your Honor. I spoke with Ms. Fair this morning.
So this is a no.
It's a no because. Judge, she went to 14.
I'm not calling the case.
Okay.
Sit down. Is she gonna be here?
Yes, she is. She was 9 minutes
Today?
away 5 minutes ago.
So what are we doing?
It's a conflict today. I don't see a signed order or the referral in here, so. No, it's just a work today. The defense.
So there's no. We didn't refer it.
Correct.
What's that? What's it set?
We referred it. No order was done and presented to you for signature. Unless I missed it.
Oh. But why do I have to do that?
Why do you have to do what?
It's a separate.
Good morning again, everybody. Welcome to the Courtroom Files Live. Happy Tuesday. So, Judge Simpson's in a good mood from the sounds of it, but his court seems a little bit chaotic and disorganized and mildly dysfunctional this morning. Hopefully they figure that out. Let's stay in Michigan, but let's go over to Judge McNally.
Number 43387, appearing on behalf of Nicholas Horn, who's on my left. Please identify yourself, sir. Nicholas Horn.
Give me 1 second here, please. There's something. All right, go ahead. I'm sorry.
Judge, here's the situation. What's happened here is he fell asleep.
He's going to have to either plead guilty or have a hearing.
He's going to plead guilty with an explanation.
All right.
At this time, did you technically violate the probation of the court?
Here, I'll go ahead and take the plea.
Go ahead, Judge.
We're going to get Ms. Tessino in here. Sir, if you plead guilty, your probation could be revoked and you could be incarcerated, as I told you, for 1 year on the attempt RNO. You've had 4 prior technical violations and 90 days on the disorderly. Do you understand that?
Yes, sir.
And did you sign, read, and understand the advice of rights? If you plead guilty, you'll be giving up all those rights. There will be no hearing or trial. Do you understand that? To the charge count 1 that you failed to submit to a SoberLink test, August 30, 11 p.m. How do you plead? You failed to submit to a SoberLink test, August 30th at 11 p.m.
Yes, sir.
Count 2 that you failed to submit to a SoberLink test, August 31 at 11 p.m. How do you plead? You failed to submit to a SoberLink test on August 31 at that time. Count 3 that you failed to submit to a SoberLink test 9/1, September 1 at 7 a.m. How do you plead? You failed to submit to a sober link test on September 1. Anybody force you to plead guilty? All right, your plea is accepted to all 3 counts. Find the plea has been made voluntarily and understandingly. Your name? Mr. Grazi.
John Graziano on behalf of Nicholas Horn. Judge, again, he's guilty, but again, there's an explanation. I know it sounds like hogwash since you've heard so much for your many years on the bench, but this gentleman did in fact fall asleep. He bust his tail. He's not some bum who just smokes some pot and just he has a few kids. He works at the Le Supreme restaurant. He pays approximately $200 a week on Ubers to get to and from work to make ends meet. And to make ends meet, he lives with his mom in Lincoln Park. And again, Judge, I would respectfully submit that this is a technical violation. It sounds like he's continuing to make mistakes, but again, Judge, this guy has got an unusual schedule. In fact, he had indicated to me that he'd like to have these sober link tests done an hour earlier for each interval because of his sleep schedule. At that time, Judge, he fell asleep with his son and he crashed. It's as simple as that. In fact,
What time does he work?
Judge, he works from 2 o'clock in the afternoon to midnight at the Le Supreme restaurant in Detroit. It's a French restaurant.
So he fell asleep while he was working?
No, Judge, this was the time. Go ahead, explain it to the judge.
Saturday, Sunday, I work brunch.
You work what?
Brunch.
Okay.
So this was Saturday night and Sunday night into Monday morning. I put my kid in bed around 10:30. I fell asleep with him Saturday and Sunday night.
Judge, again,
Well, you work Saturdays though, right?
Saturday and Sunday, I work brunch from 8 in the morning to 4 o'clock in the afternoon.
Then why weren't you up? What about Monday?
Monday is my day off. And I woke up and my phone was dead. It's unexcusable. It's my fault, 100%.
It's just been an uphill battle with him with the sober link. I mean, I gave him numerous warnings. We talked about it. I think 2 violations ago, he was doing a lot better. Saw him for the hearing for the medical marijuana card. We talked about him again because he did ask for permission to travel. I told him I wasn't going to give him permission to travel if he wasn't compliant. And then all these happened. And then I just checked it before I came in. And Sunday, the 7th, his 7 o'clock, we didn't submit to until 8:49. So I'm reluctant to even move them up because he's not submitting to the 7 o'clock. He's not going to submit to his 6 o'clock.
Judge, in response to that, while he screwed up over here, he did finally submit to it. He is working. This is a project right now that's going on. He's not snubbing his nose to this quarter to Ms. Tessino. It's this young man has a lot of issues to deal with. 29 years old, he's got 3 children. That in and of itself is a major battle to deal with. And
Are you married? Remind me.
No.
Do you live with the wife of the children?
No.
Do you share custody?
Yes.
What days do you have the children?
I know they have kids Thursday and Monday.
So she only has the kids Tuesday and Wednesday and Monday night?
yes or no?
Yes.
Judge, it's an uphill battle and
I think he's drinking is what I think.
I have not been drinking, Your Honor.
I know, but I can't verify that if you don't test.
Judge, he did test at 8:49 that morning. And what did he violate it at that time? Was there any?
No, but so his one.
Tell me about August 29th and 30th. What times?
The 30th, 31st, Judge.
I'm sorry, 30th and 31st. Tell me what times he tested on the 30th and 31st.
Seven 25 a.m., 10:46 a.m., 3:01 p.m., 7:30 p.m., and then the 11th o'clock he didn't submit to until 3:53 a.m. And then for the 31st, he had 7:28 a.m., 12:21 p.m., 3:20 PM, 6:51 PM, and then his next one isn't until 1:59 AM.
And then what about on the first?
The first is 7 o'clock, he didn't submit to until 8:44 AM.
Judge, he did submit. Granted, it was late, but he did submit, Judge. Just any other sanctions besides jail, because like I said, he's responsible for the support of his kids. This is a project right now. This is a project.
What do you mean a project?
Project in the sense that this young man has a major alcohol problem.
I know. If he would admit to that and say I was drinking, that's one thing, but he didn't. Now he wants to send me on this wild goose chase about how he fell asleep and his kid's in his arms and he does brunch and all these other things. And I don't think he's being honest with me.
Your Honor, if I may, I am being really truthful with you. I am no longer drinking. I've been trying to do everything that I can to please the courts.
How often is he testing?
He is the
He does these sober links 5 times a day, Judge. He'd be a fool. He'd be hanging himself.
I was a little late that Sunday one, but I did test yesterday. So if I was drinking, I probably would have tested for that.
How much more is the scram tether? Remind me.
the sober link 650 a day, and I wanna say the scram is 1050.
And what's the initiation or the installation fee with the scram?
$100.
Judge, without anything else being said, I would respectfully request that you allow me to use scram if it's a more aggressive program to treat this young man. Like I said, he's an alcoholic, he has his issues, and you know, he'll continue to have issues with the sober link. Hopefully scram would be better. I hope you consider moving jail.
When's his probation scheduled to expire?
Hang on, I'm just double checking the
I believe
price.
it's July of next year or March of next year.
The scram was $10 a day, the $100 enrollment.
You pay $100 in costs, you serve 1 day on the court work program, you pay $35 for that, you're to convert to a scram tether by the end of the day. And I will keep you on probation. I'm not gonna revoke you, but you are so close right now.
Judge, if he
So
continues
incredibly close.
Judge, if he continues to disregard, even though he's not doing it intentionally, he's had these issues. What jail time is Mr. Horn looking at, sir?
Why would you ask such a
I'm
question?
asking you the question to impress upon this young man that,
Well, you can get a year. You can get 1 year. You understand that? I could have given you a year just now.
Judge, thank you, Mr.
Convert to a scram tether by the end of the day.
Any more time to get the scram tether?
As long as you remain on the sober link until you do, how much time do you need to get the scram tether?
Well, I was
How much time do you need to get the scram tether?
a week.
No, why?
I don't get paid till Friday, at least. I don't have any money until Friday.
All right. They're open Saturday, right?
I believe they're open till noon on Saturday, but they're open till 7 PM on Friday.
You're gonna convert by September 12th. Defendant to remain on sober link until then. You understand that?
Yes, got it.
So I'll give you until Friday, the end of the day, to convert to a scram. You're to remain on the sober link until then. Costs and fees to be paid on this case by October the 10th. I'll give you all the way till October the 10th, okay?
Travel.
Judge, go ahead.
To go where again? For what?
South Carolina.
For what?
Take my kids to aquarium, there's also a softball tournament.
How are you getting there? Driving?
Yes.
When is that?
That's what I told him, I'm not.
When is that?
Yeah.
You're telling me you can't pay for the scram tether until Friday, and yet you're going to North Carolina before then, on Thursday, for, hang on, for a vacation. Now, it's safe to say your priorities aren't in line.
Well, I've just been working real hard, you know, the kids deserve to go somewhere.
I know,
He did pay ahead of time, Judge.
You know, I did have everything paid off.
hang on a second. You got enough money to go to North Carolina for a trip with your kids and to play softball and take them to amusement parks or wherever else. And you don't have enough money to pay $100 for a scram?
Well, we would have to pay it before it goes.
I know.
And Judge, it was prepaid. Is that correct? Did you prepay these costs?
He's not gonna be here on Friday. If he's leaving the 11th, he's not going to be here to get the scram tether. Right?
Correct.
Well, I don't know what you're saying then. I'm not gonna let you go. And you gotta push me to have me deny something like that. You're not compliant. You are not compliant. And I'm not buying this at all. I got the money that my kids deserve. I deserve. Good. You know, I don't know what to tell you. But you're not compliant enough. I'm not gonna allow him to leave. I'm sorry.
Thank you, Judge.
Thank you.
Thank you, Mr. Stino. You've made arrangements.
Are they ready on Ramiro Chavez yet?
Breakout room.
That frozen look on the judge in the lower right corner is just outstanding right now. For those of you listening on the podcast side, he has this kind of combination pouty, angry, looking over his glasses thing going on. It's just perfection. Let's get back to him here real quick.
John
There's a
Bastiani.
victim here also.
Okay, ma'am, your name? Where am I going here? What is going on with this? All right, so you want an adjournment? It was arraigned by Judge Hessen on August 29. I don't know, it's weird.
I seen it freeze and then it happened.
How much time do you need?
Judge, I need 3 weeks.
Where's the victim at? The victim on Zoom or in person, Lisa?
On Zoom.
All right,
Mr.
Joseph
Mr. Grimes, can you unmute?
Start your video, please, and tell me your name, sir.
My name's Joseph Grimes, and I'm
Okay, yeah. You have
get
to
the
start
video.
your video. It's in the bottom left-hand corner of your screen. There you go. How are you? Your name?
Joseph Grimes.
Okay. You just showed up today because the prosecutor wanted you to show up, right?
Yeah, they sent me the link and said I could join if I'd like, or
Okay. So they're asking for a 3-week adjournment, and I'm going to grant that request for them, okay?
yes, sir.
There's been no violation of the bond conditions as far as you can tell, correct? She didn't contact you, right?
No, we did have another incident where she come close to the house while I was gone. But as far as I know, just like the officer said, there was no violation of the order.
Judge, if I may respectfully request the opportunity for her to see her daughter. They do have both Mr. Grimes and Mrs. Grimes.
I don't, you know what? There seems to be this epidemic of people that think they don't have to comply with orders.
Judge, it's simply to make arrangements to see that.
No, I get it, but where did you find this out, Mr. Grimes?
I actually was in a counselor's appointment and my daughter was texting me, saying that she was trying to come over and get stuff, Your Honor. I tried to make arrangements prior to that to get her the things that she needed. And then, when I went to my counselor's appointment, my daughter had informed me that she was trying to come over and get the rest of her stuff. And, when I left and got home, is when I seen that, her and her mother were there. Apparently, Jacqueline was still in the truck. I did not know that, but when I pulled up to the house and seen her mom, I called 911.
Ma'am, were you trying to go back to?
No, sir, not. I was taking medication that I could not abruptly quit taking. I contacted the pharmacy. I could not get a refill. The refills refilled August 24th.
Okay, so you did try to go back to the house.
But I did not get out of the truck. I did not go within 100 feet of my home. I did not I didn't go anywhere
Okay.
around.
All right, listen. If she needs to go back there, I don't have a problem with that, okay? But you cannot ignore court orders. Judge Hessen set this bond. I expect you to comply with it. You're not to enter the property address at 28501 Waddell in Brownstown. You will be allowed one visit and one visit only, accompanied by the police to acquire your own personal belongings, okay? So you're gonna have to call the police and talk to them. Who's the detective on this? Can somebody tell me here?
Officer Fox.
Officer who?
Fox.
Well, this is probably, okay. Can you get Ms. Louie in here, please? So what I'm gonna do is, I'm gonna change the bond. I'm gonna add a condition here that allows you to go there. No contact with Joseph Grimes or prosecution witnesses. You cannot enter or go near 28501 Waddell in Brownstown. I will allow you one visit only, accompanied by the police to acquire your own personal belongings. You're not to possess firearms. You're not to possess dangerous weapons. I'm gonna help work this out right now. We're gonna get Ms. Louie to contact Detective Claft and whoever else can make arrangements for you to meet there. So, Mr. Grimes, I think it is advisable for you to be home when she comes over, but let's not have anything going on there. Ms. Louie, your name? Good morning. So Ms. Grimes was trying to go over to the house. She needs to get meds and other things. I'm going to ask you to call Detective Claft and make arrangements for maybe through her lawyer so the defendant can go back there and get her own personal belongings accompanied by the police at a time when Mr. Grimes is there, okay?
Not a problem. And I did ask Lisa to put me in the room with Mr. Grimes. I haven't been able to.
Okay, so, and she wants to speak to you in a room, Mr. Grimes.
Did you put a date now? You have the victims here, maybe a date that works for both of them.
Well, as long as the police can get there, when's a good date for you, ma'am? Let's talk about you. When's a good date for you to go over there and get your belongings?
I mean, honestly, the sooner the better. At this.
Okay. Would you have a problem with her coming today?
I'm actually at work right now, doing some onboarding for my company.
That's all right. When do you work? What hours?
I would be there, probably after 5 o'clock.
What
But,
about
Your
tomorrow?
Honor, when the police came, last Thursday, I did give her a bunch of stuff then also.
I know. I'm gonna let her go back. Listen.
Okay.
I'm gonna let you guys work it out. I don't have to referee this. Okay?
Judge, I appreciate it. It's simply credit cards and closing.
I understand.
So,
Thanks. You guys figure it out. It should not be hard. If I need to intervene, I will, but it should not be hard. Thank you. Chavez, Hilario Romero Chavez, Tupac D 718463. Okay, where is the interpreter on this? Good morning. How are you, Ms. Heisley?
Good morning, Your Honor. I'm well, thank you.
Well, let's change it up a little bit because interpreter stuff can be lengthy and tedious, and it seems like he's having lengthy and tedious already today. Let's go to Texas, Judge Stevens.
Rolando Ramirez III. That's you? Yes, sir. Ms. Minaldi, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes.
In summary, this indictment alleges that On or about March 11th, 2024 in Jefferson County, Texas, you committed the third-degree felony of failing to comply with sex offender registration requirements. Do you understand what you were charged with?
Yes.
If convicted of a third-degree felony, you face no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
You understand? Wow, she's gonna take that.
Yes.
An agreement's been reached in your case where whatever sentence shall not exceed a cap of 5 years in prison. So I guess we're looking at no less than 2, no more than 5 years confinement in prison. You could be placed on deferred or unadjudicated probation for up to 10 years. That's not a finding of guilt. And if you fail on probation, your probation could be revoked. You could then be found guilty and sentenced up to the full range of punishment. Then you could be sentenced to no less than 2, no more than 5 years confinement in prison. And then I could suspend that and place you on regular probation for up to 10 years. I think those are the 3 options that we have here in all of this. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
If you put your
They're finicky.
This is the way I was taught. It's like backwards. All the families ended up like that, seemed like. How do you plead to this third-degree felony in this indictment, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes.
Show you what's marked as State's Exhibit 1 there. Did you sign that document voluntarily? Understand it? Discuss it with your attorney?
Yes.
Or the contents all true and correct?
Yes.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection, it's submitted. Among other things, this states you are mentally competent to enter your guilty plea, which is freely and voluntarily made. Hey, Raj, you want one of these?
Oh,
I know you're sneezing on the defendants. Yeah,
Okay.
it's all right. He's getting better actually, but it's a work in progress. You were totally satisfied with the representation provided by your lawyer. You're giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You're guilty of this offense and all lesser included offenses. And all of this is true. It states, so help you God.
Yes.
States Exhibit 1, made a part of the record for all purposes. And again, how do you plead to this, guilty or not guilty?
Guilty.
And you are pleading guilty voluntarily and based upon discussions with your attorney.
Yes.
Okay. What we're going to do is postpone a sentencing until we get a pre-sentence report.
Yes, Judge.
So
Requesting.
we will be back in a few weeks. All parties will be able to review the pre-sentence report, then add any information you want me to consider, and then I will make my choice. Here in this situation, let me ask you, are you currently properly registered?
Compliance, yes.
Okay, well, you know, it has its consequences, up to 10 years in prison. So you don't want to flirt with that. What happened here? Did you just kind of let it slip by?
I'd been moving a lot from town to town.
Yes, sir.
I went from Florida to Port Arthur to Houston to Groves, Louisiana. I just moved around a lot, and then I just wasn't in compliance.
Okay. Well, you know, it's got serious consequences. Yes. It's very important that you don't want to flirt with this. And is this lifetime?
Yes.
It's lifetime. It's not a cap at 20. Okay. All right. Well, it's got to be one of the more important things on your list.
Yes, sir.
Okay. All right. Please get a resetting and we'll see you back then. Okay.
Let's go to Miami-Dade. We'll see how Judge Glazer's holding up this morning.
No weapon was seized.
No, ma'am.
So even though they didn't find a gun, they have to rely on the facts, 4 corners of the arrest affidavit. And in here, it says that you pulled a gun on her. That being said, and there's nothing, you could have tossed the gun. You're ordered to stay away from the alleged victim. Ann J. Smalls, no contact with the alleged victim, Ms. Smalls, either directly, indirectly, in person, in writing, by telephone or through third parties. No contact with the victim through social media or other electronic means. And you must stay at least 500 feet away from the victim's home and school and place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs, and do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. Do you understand the stay away order, sir?
Yes, ma'am.
He has no priors. Do you see any juvenile priors?
There was some juvenile history.
I mean, what do you want me to do? Give him a bet, house arrest?
Or a bond because it involved.
Okay, with house arrest, given the circumstances. House arrest with a GPS monitor,
Yeah, I'll do house arrest, GPS.
alternate bond, it's $5,000. I'll do level 3 house arrest, which is GPS roaming. However, I'm giving you a curfew from 11 p.m. to 6 a.m.
Yes,
Sir,
ma'am.
if you want to see your child, I think you're gonna have to go to family court and file a petition.
Yeah, that's what I want to do because I was trying to explain to her my check didn't come on Social Security. Then that's when she started cursing me out, talking about, oh, that's why them niggas hit you in the head with the chopper. That's why I made them niggas hit you in the head.
So let me explain something, okay? I know you're an adult, you're
A lot of
19,
stuff.
and listen, I know you're a big man, big boy.
Yes,
You're
ma'am.
19 and you have a child with the
Yes, ma'am.
victim. In order for you to have visitation rights with the child, you have to go to family court and file a petition to determine paternity. That way a judge you can establish, you want to also do a DNA test to make sure you're the daddy. Because sometimes when I was in family court, years later, the dads get a DNA test and they're not the daddy, but the biological daddy, but they acknowledge paternity and then they're on the hook paying child support. So go there, file your petition. There's a self-help office on the 24th floor of the Lawson E. Thomas Courthouse Center. That's at 175 Northwest First Avenue on the 24th floor. So they'll sell you a package. I think it's like $65, but if you can't afford to pay for the package, you do an affidavit, filling it out, telling them what your finances are, and they may even waive it or make it $5, whatever. After that's filed, you fill all the paperwork out, you bring it back, they review it with you, and you're ready to file it with the clerk of court. There is a filing fee involved of, I think, $401. But even there, if you fill out an affidavit of indigency that you can't afford to pay that money if you're not working, or you can't afford it because you have a lot of debts, they'll waive the fee. So once you file your papers, you can go in front of a judge. That judge will probably send you to a place called mediation, where you meet with a person who tries to work out a parenting plan and time-sharing schedule. But that way, you will be able to see your child and they'll write down how you should pay child support, and then they take it out of your Social Security check or any other check you have. Do you understand?
Yeah, she don't got me on child support though, but I go get a baby, this stuff.
Don't buy the stuff because you're still going to be obligated to pay a certain dollar amount, okay? Keep receipts of whatever you paid for. But that's what you have to do.
That's
Stay
what I
away from
do.
the
I
victim.
take pictures and stuff. And she just
Listen,
she
if you
just-
go to family court and they take it out of your check, then you don't have to worry and you avoid these problems in the future. So now that you have a child and you're 19, you have to start acting like an adult. It's time to grow up and be responsible, right?
That's what I'm doing. It's just you don't know how she is towards me.
But this protects you. Going to family court and getting that a time-sharing schedule by a judge and a child support order for a certain amount you have to pay every month protects you, and she can't keep the child from you. So, Mr. Wilson, do they still have the papers there in the back for self-help? They used to have them there in the back.
I'll note it on the calendar.
That's
Reach
what
out
I
to
was
Mr.
gonna ask you.
Hodge
Can I
afterward. I know
get
Ms.
some
Porter
papers?
can maybe discuss
I
it.
couldn't hear you, sir.
I was just gonna ask, can I can somebody show me what to do, like some papers and stuff, so I can.
I
give
just
to my
told you
mom
to
so
you.
she can get them?
We had papers there at the public defender's office. Are they still there? Does Ron have them?
I'll check with Miss Corey because I know some things have been moved around, with the sound system and everything. They had to move some of the equipment paperwork. So I'll check with her when she comes in and reach out to Mr. Hodge.
If not, I can get more forms and email it to you, to Miss Corey, and she
Oh,
can give
yes,
them
ma'am.
out, okay?
Oh, that'd
But
be
you
great.
want to go to the Lawson E. Thomas Courthouse Center at 175 Northwest First Street, the 24th floor. Go tell him Judge Glazer sent you there. You need to get a parenting plan and time sharing schedule, okay?
Yes, ma'am. Thank you very much.
Good luck to you, sir.
You too.
Have a nice day. Next, we have Roberto Permoy.
Your Honor, he was taken to Metro West, so we need to reset it for the PM calendar.
Thank you. He's also, yes.
I don't know if council wants to waive his presence because he's out on felony bond.
There's probable cause for the charge. It's on felony bond on F-25 13475. Mr. Wilson, you want to waive his presence or do you want me to?
Yes, Your Honor. Oh,
All
we'll
right, I
waive
set a bond, it's $2,500. Appoint the public defender's office, waive presence. There's probable cause.
2 counts, Your Honor.
Oh, it's 2 counts, 2,500 each count, and he'll see the judge tomorrow, the division judge tomorrow. Next is Juan Arellano Ibanez.
Yes, Your Honor.
Good morning, sir. You were arrested for sexual activity with a minor and stalking. So I will, can you afford to hire an attorney, sir?
No, I had a free one pointed towards me.
You don't get it until I say you get it. Do you own your home?
No, I don't.
I will appoint the public defender's office for you. So let me review.
you.
This is a case that goes back to August 26th. So don't talk about the charges. You have a lawyer standing next to you, Mr. Wilson, and he's going to represent you, okay? Let me review. You may be facing other charges. So the victim's 17, and then he's admitting to the victim's family what happened between him and the victim. Then he changed her social media accounts, posting from her account impersonating the victim, making derogatory statements in the posts. And it's like some type of a communications crime. I guess that's stalking, but there may be other charges. I'm not sure. Sir, you're ordered to stay away from the alleged victim, the 17-year-old child whose initials are NM, no contact with the victim, either directly, indirectly, in person, in writing, by telephone or through third parties, no contact with the victim through social media or other electronic means. That means if you impersonate her on social media, you could be facing additional charges. And also stay at least 500 feet away from the victim, her home and school, and any place of employment at all times. Do you understand the stay away order, sir?
Yes, Your Honor.
Thank you. So I don't know if it's stalking or aggravated stalking. I'm going to find probable cause for what's charged herein. Count 1 is $7,500. Count 2, stalking, will be $1,000. Good day, sir.
So is that 8,500?
Yes, sir. You can call your bondsman to get out of jail. Just stay away from the victim. Good day, sir.
Yes, ma'am.
Thank you. Next, we have Andre Soto.
There may be an issue on count 3.
Thank you.
Like English, Stan? Yes, sir, English.
Just find the paperwork 1 minute. On page 6. Good morning, sir. You were arrested for strong arm robbery, child abuse, no great bodily harm, aggravated assault with a firearm, and battery. Sir, can you afford to hire a private lawyer?
Not really, Your Honor.
All right, I will appoint the public defender's office for you. So there's probable cause for count 1, strong arm robbery. I think count 2, he pushed the victim on the bed while she's carrying her 6-week-old baby. So count 2 would be, I think, child neglect state. I'm not sure. Doesn't say the child was injured.
It was a tiny baby though.
Sir, you are ordered to stay away from the alleged victim, Tiffany Meek. No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means, and you must stay at least 500 feet away from the victim, her home and school and place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs, and do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. And sir, did the victim move out of your house?
Yes, ma'am.
All right, so you sure she's gone? Otherwise, you can only return one time only with a police officer.
No, she's gone. It's my
Okay.
residence and everything was already taken care of.
Do you understand the stay away order, sir?
Yes, ma'am.
Thank you. So count 1, there is probable cause for strong arm robbery. I'll set that bond at $6,500. Because I'm going to split it with count 4. Count 2, there's probable cause for child neglect. That bond is $2,500. Count 3, there's no probable cause for aggravated assault with a firearm. Release outright. And count 4, there's probable cause for battery. I'll set that bond at $500. So the total bond is $9,500. Good luck to you, sir.
Wait, can I ask her about the baby? Your Honor,
Yes, sir.
how do I go about getting custody, or not custody, but what do I do about?
Well, if I was the family court judge, I wouldn't give you anything, only supervised visits. So lucky it's not me. But if you want to see your child, you should go to you can either hire a lawyer who does family law. You can contact the Florida Bar. You can also go to the Lawson E. Thomas Courthouse Center at 175 Northwest First Avenue, the 24th floor. There's a self-help office there. And at that self-help office, they'll give you a package you can purchase. I think it costs $65. If you can't afford it, they'll waive the fee or reduce it. You fill out the paperwork. It's a petition to determine paternity. And so you fill out all of your information and then you make an appointment to go back. They review it. And if everything's in order, you file it with the clerk of court in family court. The filing fee is $401. If you're unable to post the $401 filing fee, you can fill out an affidavit of indigency and see if that will be waived. So once that's all done and you file it with the clerk, you would go before a judge or a mediator, see if you can work out an agreement. And if not, you'll have a trial, but you have to go in front of that family court judge to establish your paternity and to get a parenting plan and time sharing schedule. You may also want to have your DNA checked, which they can do over there through Family Court Services to make sure you're the father, because once you accept that obligation without the DNA testing, if you find out later on in life it's not your child, you're still on the hook to pay child support.
Yes,
Did I answer your question, sir?
Yes, thank you very much.
Good luck to you, sir.
I appreciate
Have a nice day.
Thank you.
All right, let's move on for a little while. We'll go back to Texas, but let's see Judge West this time.
Mr. Stratton in cause number 19-33601, charged with capital murder, and this we're back again on this. Mr. Radford has been appointed to represent Mr. Stratton. And Mr. Radford, have you had an opportunity to get started on discovery?
Judge, I have gotten a transcript. I've got a huge trial docket coming up in the next 2 months, and I haven't had a chance to read it. I have also visited with Mr. Stratton. I've gotten discovery from Ms. I've gotten the paper discovery from Ms. Malfino, and we have visited preliminary excuse me,
Easy for you to say.
initially, about a possible resolution to this case that doesn't involve trial, but we're gonna have to do some further negotiations, and I think she has to visit with some family members.
Sure. And I know there's probably also some audio, video and things
Yeah, I
that you
haven't
need to
got-
get.
Yeah, I haven't got any.
So obviously, Mr. Stratton is going to take Mr. Radford just a little bit of time to get up to speed on this. And so what I'll do
We've
based
been
on.
working to recreate the file, Judge. It just was in several different places, including the district clerk's possession. I have prepared a written notice asking them for the trial evidence to be returned to the possession of the state.
Okay.
I also have the transcript thing.
I've gotten the
To
transcript.
Ms. Tanner, and we will begin going through that and recreating the file. If there's anything additional Mr. Radford needs, he knows I have an open door.
Judge, could I get 60 days on this?
Well, I was thinking for sure 60.
Yeah.
I mean, I think realistically, obviously, it's going to take you some time to get up to speed, get the file recreated. We don't want to put it off too long. We need to get it taken care of, but I know everybody needs some time. So we're in. We're in September. We're not in August anymore.
I've got 4 huge trials.
Well, so why don't we do this? Why don't we come back first part of December, which is about 70 days, 75
Right.
days-ish. Let's find out where we are. And at that point, if you guys could at least have an idea if it's going to trial, then we can get a special date next year so that everybody's ready and available. And we'll get it set at that point if we need to for trial.
Yes, ma'am.
Okay? All right. Thank you. You can go back with the bailiff. Mr. Parker?
Yes, I'm working on something on that now.
Okay, I'll hold yours. Mr. Burbank, you have Brandon Dodd. Morning. Morning, Mr. Coleman.
I want for you because I knew you were gonna wear yours, and I didn't want you to be taller than I.
I gave it right out of the gate. I gave this man a compliment. I gave this man a compliment right out of the gate.
Good morning, sir. You're Brandon Dodd?
Yes, ma'am.
And Mr. Dodd, in cause number 24, DCCR 2418 is charged with murder. And what is the announcement?
Your Honor, he previously rejected 35 years. We asked him to stay on the trial docket. We have everything.
Okay. So there's no other negotiations. And Mr. Dodd, we've already gone through what you're charged with, what the possible consequences are if you go to trial. And you visited now with Mr. Burbank and you want to go forward with your trial. Is that correct?
Yes, ma'am.
Okay, we'll get it set on the next available trial docket and we'll see you then.
There is a co-defendant if you want to keep them together.
I don't know that we're worried about keeping them together.
Oh, okay. I
Yeah.
just didn't know if you were-
Okay, thank you. All right, you can go back with the bailiff. And then you've got Traylon Hill. Not for me, for somebody else, unfortunately.
Good morning, Your Honor.
Good morning. How are you?
Doing great.
This could, this is just to go to whatever, do you have the orders on those Burbank's motions? Good morning, you're Traylon Hill. And Mr. Hill, in cause numbers 24 DCCR 1500, 1614, 1615, and 25 DCCR 0436, Mr. Burbank has been hired, I believe, by your family to represent you. He has filed motions to withdraw in all of those cases. And so do you have any opposition to me allowing him to withdraw?
No, ma'am, not at all.
So, Mr. Burbank, you are released on all of those cases. Mr. Hill, because you are in custody, I will appoint an attorney today who can begin representing you and get ready for trial in all of your cases. All right, you can go back with the bailiff.
Missed a fun chance to talk about his behavior again.
Is there, I think she printed it out.
All right, well, we wait for the next contestant there. Let's stay in the same house, but go over to Judge Stevens.
Attorney and the state's attorney. There's a motion here to suppress audio portions of the videotape. I must say, I haven't reviewed it.
Well, the state has no objection to redacting the portions that they've asked for us to redact, so.
All right. It states specifically at minute 26 until minute 27. And there is no objection from the state. All right. I'm going to, huh?
It's more than just 1 minute. It's all the
It says
references.
specifically at minute 26 until minute 27.
There's multiple,
Contains portions
with multiple people.
It says defendant contends that that's misspelled. Portions of the videotape produced from the body worn camera of the officers contain reference to previous convictions or extraneous offenses of the defendant. Specifically at minute 26 until minute 27 in the video produced from Officer Garris's body worn camera. The officer mentions a prior offense of the defendant, and then there's Claire is next. There's another one.
There are several officers. We have no problems getting rid of what they've asked for, and Mr. Shalander has given me a list of what they would like us to redact, and I have no issues redacting any of those things.
All right. You heard what she says.
Thank you.
Let's see. Granted, Ms. Warner. Mr. Shalander is stating that there's more than just that 1 minute. Apparently.
Give me a list.
Oh, okay. All right.
That's
So
fine.
we're gonna, your agreement encompasses what's outside the motion for all other parts. Okay. Okay. Anything else? Okay. We're set for trials, I guess, next.
Wednesday, or I mean, next, not this Wednesday, next Wednesday, I think.
Trial?
Or next, what day?
Anyway, it's set for trial sometime coming up. Okay.
This month.
Good. Please.
9:22.
Thank you. All right, John, you're looking at some stuff here.
Yes.
Yeah, get a resetting there. Hi, Coolin. Okay, Andre Morat.
I've got paperwork ready to give them a sign and we'll play it.
All right, Orlean Neely.
Mr. Neely is right there. And when he said this one on the trial, that we get to the point where we can't get this resolved.
Neely,
Yes.
24 CR 1339. That's you?
Thank you. No. We just gotta say, we're gonna come back. Yeah, I'll take care of you.
It's always good to get the right defendant in there. How about Orlean Neely?
That's Mr.
The
Neely.
real Orlean Neely.
And the white shirt, yeah. This is the
And
one.
nothing but the real Orlean Neely. That's you?
Yes.
All right, according to Mr. West here, this is going to be set for trial. It's right? That's what everybody wants. And look at this. See. It's a second-degree felony, which carries with it up to 20 years in prison. Do you know the victims in this case? Cassie Shoemaker, do you know them?
No.
Okay, all right. Because one of the rules in place in all cases here is that the defendant cannot have any contact with the victim nor anyone on their behalf.
I don't think he has any here.
Okay, then it's set for trial.
It's not too, got it.
Then I've got Christian Simeon.
Mr. Simeon's right. Yeah, you can get this right, Christian.
Wait, mama, this.
Yeah, so, we need to sit the phone.
I'm sorry.
This is Neely, this is, Mr. Simeon.
Cindy.
Yeah, I thought you like that.
Hi, sir.
Set for trial? Okay. Then it will be tried.
Yeah, we should get it. You're free to go. I'll talk about that. Yes, sir.
Paul Smith.
Paul Smith is right there. If we can give it about 2 to 4 more weeks.
It's a year over, well over a year old. We don't have that. He looks like he's got, we go roll in on a motorcycle.
Maybe. But he's got a good work after this.
I'm just a premium, sir.
Oh, okay. All right, you're charged with a state jail felony of theft. And yeah, it was last May, it was a year old.
Yeah.
Come on, we don't have time.
I was told that.
What are we gonna do?
Witness.
Fisher cut date. Let's go.
Well, at that point, we're going to set for trial.
Set for trial. That's what we're gonna do. Set it for
Yeah,
trial.
we're setting up. Yes.
And then James Wilson.
I'm going to leave your paperwork ready to get it signed, so give me some time. What? I say time is enough to everybody sign the paperwork.
Okay.
You have it right now?
Yeah. That's one thing. Yeah, Jamal Mosley. Jamal Mosley. Great. And then Christopher Wyndham. What's that?
Okay.
What are we doing on Wyndham today?
My understanding is you're announcing on legal wage. You've heard arguments from defense and what's that say multiple times and had briefs on that.
And John had Ty Cooley and Andre Morales. And finally, Willie. What are you doing with Willie Leday?
That's the hearing with Brian about his continued
Oh, that's the add-on.
competency issues too.
Who's?
I was going to say,
The defendant?
You won't need any direction from the state.
What does that say when the whole room
Yes, that joke.
bellows out in unison?
It says that it's long overdue for violent judge.
Okay, so who is it? Right now, you've got
Jamal Mosley.
Jamal Mosley. Thank you. Jamal Mosley.
Raise your right hand, sir. If you swear or affirm to tell the truth, the whole truth, and nothing but yourself, you got? Place it right there. Can you get up one more time? Place it right there. All right, dude. Judge.
24 CR 1683 is called. Let me just sit back and drink our coffee. 24 CR 1683 is called. The state of Texas versus Jamal Gregory Mosley. That's you, sir? Yes. Present with Ms. Minaldi, your attorney, and the state's attorney. Does the defendant give a formal reading of this indictment and the arraignment here? Can we proceed to summary?
Yes.
In summary, this indictment alleges that on or about May 1st, 2024, in Jefferson County, Texas, you committed a third-degree felony of unlawful possession of a firearm by being a convicted felon. Do you understand what you were charged with?
Yes, sir.
If convicted of a third-degree felony like this, you are facing a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range you are facing?
Yes, sir.
An agreement's been reached where whatever sentence shall not exceed a cap. It's cap day today.
It is cap.
Will not exceed a cap of 5 years in prison. So what this means is, looks like we've got three options. You've got no less than 2 nor more than 5 years confinement in prison. That's what's happening. You could be placed on deferred or unadjudicated probation for up to 10 years in length where you are not found guilty. But if you fail on probation, your probation could be revoked and you could be sentenced from no less than 2 nor more than 5 years confinement. Then there's regular probation, where you plead guilty or found guilty, sentenced up to 5 years in prison, and that sentence is suspended and you are placed on regular probation. So those are three options. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
10-second delay. I'm going to show you what's marked here. States Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney?
Yes,
Are the contents true and correct?
Judge, I think it's on the wrong page.
States Exhibit. Stand by. Here's States Exhibit 1 right here. Look at that. States Exhibit 1. Did you sign that document? Discuss it with your attorney? Are the contents all true and correct?
Yes.
States Exhibit 1 tendered in.
No objection.
Without objection, it's submitted. This states you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. It's read to you. You read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All true, so help you God. States Exhibit 1, part of the record for all purposes. As one of the other cases before, what we're going to do is order a pre-sentence report, and then we will work with the probation officer here in a minute, and then we'll come back later. All parties will have a chance to add any information they wish, and then the court will make its decision. Okay, please get a reset then. Thank you.
Just sign on the X right there for me. Probation.
No.
All right, let's go check back in with Judge Simpson, see what's going on up in Michigan.
Your Honor. Count 1 is dismissed. I'll continue a not guilty plea as to count 2. This will be set for pretrial
October 16th at 10 a.m. with Judge Washington.
October 16th, 2025, 10 a.m. before Judge Washington.
Thank you.
Judge, do you know if that's by Zoom or in person? How am I supposed?
Really?
How am I supposed to know that, Ms.
We were
Aguilar?
almost out of here. I'm sorry,
How,
Judge. We
do
were,
you want us to find out?
no, Your Honor, we
Ms.
will
Fair, did you want
call.
me to find, I'll
No,
find out.
my boss is already, I have to go back to work. We will call and find out all the information we need for the hearing, Judge. Thank you.
Do you have another case?
I've got 3 in front of you today, Your Honor.
Oh, joy. Thank you, Ms. Fair.
Thank you. Have a good one, sir. Thank you.
Do you know if that's, I have no idea. Court does call the case of the people versus Vincent Lambert.
Brian Bowling on behalf of Mr. Lambert, Your Honor, who's approaching.
Vincent Lambert. The rest of the date comes at preliminary examination. At this time, the people are unable to proceed.
I would move to dismiss then, Your Honor.
People being unable to proceed, this case is dismissed on the motion of the defendant. That's without prejudice.
Thank you.
Thank you.
See you.
He's back.
No, they're witnessing. I mean, I can release the other one. Would you? I talking to them. I don't think
This is a comp review. Does call the case of the people versus Montel Gatton.
And the Assistant Public Defender, Chinazi Akin Ruli, Your Honor, on behalf of Mr. Gatlin, who's approaching.
Could have done this before he came out. Okay, no, I didn't mind waiting.
Mr. Gatlin, state your name for the record, please.
Montel Gatlin. Thank you, sir.
So, Your Honor, we are here today for a competency review. I have spoken with the doctor at the Forensic Center. He states that the report will be done by the end of this week.
That it will be done by the end of this week.
That's what he said, yes.
Okay, then what I will do is I'll adjourn the comp hearing, no report, to September 30th, 2025 at 9 a.m.
Okay, Your Honor.
I'm putting it with my PCC docket at 9.
What date,
Pardon?
I didn't hear the date, Your Honor. I
You
apologize.
didn't what?
I didn't hear the date that you gave us.
Did I? Was I loud enough? Or was she not listening? Which do you think it is?
I wasn't paying
Because
attention.
Mr. Johnson heard the date. Everybody heard the date but you.
I apologize.
Why is that?
I was multitasking, but I wasn't doing very well.
September 30th.
Thank you, Judge.
2025, 9 a.m.
Okay. Your Honor, my client would like for me to address bond, please.
Go ahead.
Judge, Mr. Gatlin reports that he has an address where he will be living with his aunt. He states that he has a job waiting for him with Root Plumbing Company, where he will be able to make very good money. He states that he previously requested that my office be removed from his case. He's trying to see if he can raise money to pay a private attorney to handle his matter for him. I think in the meantime, I will reach out to the Office of Assigned Counsel and see if we can get him someone temporarily. However, he wants the court to understand that he is okay with a tether of any sort that the court deems necessary to allow him at least to get out and start working. We know that competency is at issue, but I think that a tether would be able to cover any issues that the court or the people may have in regards to complaining witnesses and safety as well as flight risks, Judge.
Response.
Your Honor, we asked that there not be a change in bond. Given what the allegations are here, we don't think that a tether by itself would be sufficient. With the fleeing case, we have Mr. Gatlin allegedly fleeing from multiple officers, and officers trying to pull someone over isn't sufficient to make them stop. And I don't know why a tether is something that would make somebody stay at home. Here we have the allegation that he fled at such high speed that he crashed his car and then he fled on foot, and that he had 2 children in the car. He left. Police found money near the car, and so it would be that it's not high flight risk and danger. So we're asking that why not.
The court's going to deny the request to change the defendant's bond. In this case, the court would find, given those circumstances, at least as alleged, that the defendant would pose a risk of flight, and also that he poses a danger to the community by leaving the children at the location that he did. So his bond will continue.
Thank you, Your Honor. Thank you, Judge.
Thank you.
Let's head back to Texas. Judge Stevens has a new contestant.
I have access to him.
Andre Morales, that's you. 24 CR 1409 is called. Andre Morales, who's here with Mr. West and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in sum?
Yes, Your Honor, please.
In summary, this indictment alleges that on or about July 30th, 2023 in Jefferson County, Texas, you committed the state jail felony of abandoning or endangering a child. Do you understand what you are charged with here?
Yes, sir.
All right, this is a state jail felony, which means if convicted, you face no less than 180 days, no more than 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand the punishment range?
Yes, sir.
An agreement's been reached where you would be placed on deferred or unadjudicated probation. And that can be up to 10 years, up to 5 years in length. There is no fine here.
No, sir.
And there would be terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the plan?
Yes, Your Honor.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily, that is on your own free will and because you are guilty?
Yes, Your Honor.
I'm going to show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents all true and correct here?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with representation provided by your lawyer. All true, so help you God.
Yes, Your Honor.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
Please, Your Honor.
And you are entering your plea of guilty here voluntarily, knowing this intelligently and after thorough discussions with your attorney.
Yes, sir.
All right, I'm going to follow this agreement then and find that you are indeed mentally competent to enter your guilty plea. It's freely and voluntarily made. There's enough evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm going to defer any finding of guilt so long as you follow terms and conditions of probation that the probation officer is going to review with you. Make sure you do. This will be for 5 years in length. If you fail, your probation can be revoked. You can be then found guilty and sentenced up to the full range of punishment, which is up to 2 years in the state jail. So please see the probation officer. Thank you.
I son now. Talk about that, sir.
Dennis, go tell the jury we're going to need about 15 more minutes anyway. We got, but thank them for their patience. Thank you. Is it Ty Cooley next?
Yes, I'm getting his.
All right, well, he waits for the next guy. Again, let's stay in the building, but go back over to Judge West.
Harrington Scott. Like I said, because I got used to that yesterday, saying your first name, because we had a hearing with Bruce and Philip yesterday, so I had to.
One way it gets more fun is if the defendant's last name's Smith also.
I know. All right, are you Carrington Scott?
Yes, ma'am.
Good. And Mr. Burbank, will your client waive the formal reading of the indictment?
Well, yeah,
We're proceeding on the lesser included, Judge.
Thank you. Mr. Burbank already alerted me as well. Appreciate that. Let me get that pulled up the right way. Mr. Scott, in cause number 25 DCCR 0538, the state has elected to proceed on the lesser included offense of a state jail felony theft from a person, and that's from March 20th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
no objection to state's warrant.
It's admitted. Is there any evidence that Mr. Scott is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft from a person. Sentence you in accordance with that agreement to a term of 180 days in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification. That shows that this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Burbank.
One other thing.
Yes, sir.
This is a pending felony, misdemeanor, out of misdemeanor court. I don't have it. It's resisting out of this incident, and Mr. Smith said he was going to dismiss it as part of it.
Okay, and so Mr. Smith, you'll take care of that down in misdemeanor court, and they'll get that case dismissed quickly, all right? You can go back with the bailiff, sir.
And then call me when you have Mr. Ross.
I have it. We can get Mr. Ross out.
Judge, I need to sound for him first.
Okay, that's fine. What? How many does he have? Please, ma'am. And I only see paperwork on one, though. Did y'all not do paperwork on both of Ross?
Just one.
1199.
What about the other MTRP?
Want me to do two?
They're both MTRPs. Yeah, you gotta, yep.
He has a new offense, Judge. I have tendered the probable cause on that. It has yet to be indicted. Our proposal, if the court would allow, is for him to go to ISF. I was gonna hold that in the case to see if he successfully completes and then take care of it later, or I can have it indicted tomorrow, whichever the court prefers.
Okay, I'll look at it in just a second once y'all get all that done.
All right, Judge Stevens has the next contestant lined up now, so we'll go back to him.
And looking at the probable cause affidavit, this was, you were arrested while driving a vehicle with a child.
Yes, sir.
8-year-old child. So apparently there were drugs, pills that were being taken for what?
I have lupus, and then mental health. And it was for mental health. One more time. The Beautiful is mild pain medication that I take for lupus, and then the lorazepam, which I have generic now, is clozapam, is for my mental health issues.
All right. What are we doing here? In what's the difference right now as she's standing in front of me testing positive with these drugs, and then driving while intoxicated with a child that day?
It's different.
What's the difference? Because how do we police the difference? Because too often people are up here playing with the drugs, and then we're all in a disadvantage of trying to figure out how the game's being played, where somebody can use drugs and still try to manipulate the system. What was it? What happened here on this case that caused the indictment? That's what I want to know. What caused the indictment to happen? She got drugs right now in her system. She had drugs in her system right here. She gets indicted for those other drugs. Did she have a prescription for those drugs?
I'm not sure at the time, Judge, but now she
says yes. And okay, she got indicted. So why do you think that happened? I mean, but we've got a child here being driven around, and she's testing positive for drugs. And look, what people want to do for their own self in their own private way, there's not much we can do about it. I wish they wouldn't hurt themselves unless they need help. But you've got a child at risk. A crime is being committed, and it's serious. A child is just along for the ride. They're just being hauled off, and they're put in harm's way, according to the indictment. Now, you're testing positive. I'm in a bad position. What am I saying? How do I police this? How do I maintain the safety of the community if she's testing positive for drugs and she was indicted for the same stuff? Now she's got a prescription. How did that? She had a prescription then?
Yes, sir.
What happened? How did she get indicted? If what we hear, we've got to get out of jail free card.
and those are things that we're working on, Judge, but she has
Well,
taken.
look, here's the problem. This was indicted back in February. You got to work on that quicker, because she just tested positive. And what am I supposed to do? Let her go out and get in the 4,000-pound missile and drive off? No, you can shake your head all day long. This is rhetorical. I really, because I know what I'm gonna do, but I've got a problem here.
Judge,
She was indicted for prescriptions that she had. Why did the grand jury do them? They generally make the wise choices. Why did they do that? Because she's testing positive now.
And
And how do I police it? How do I know she didn't take more? How do I know she didn't take too much to make her really incapable of driving a vehicle responsibly and putting all of us in harm's way? This is a glitch that I don't want to be put into. It's heads you win, tails I lose. I don't like that. How do I police a defendant like this responsibly when she's testing positive? And says, well, look, I've got prescriptions, but I had prescriptions back then, but they indicted me for that. I mean, aren't we doing a circle here?
Judge, if I may, she has taken the proactive steps to not be put in this similar position again. She has taken the proactive steps to not.
What is she doing?
She's not operating a vehicle currently. She doesn't even have a vehicle. Every time that she has a court date, her friends are driving her.
Who
her
drove
aunt
you
is
up
driving
here?
her.
Her name is Liv.
Where is she?
She is in the parking lot. If anybody wants to escort me down there, she is. She's down.
Sitting in the hot car. She didn't come up in the.
She probably has the ignition on, Judge.
And the ignition on?
She's probably just waiting.
Carbon monoxide?
It's,
Do you not?
it's a pleasant day, Judge. I'd sit outside today.
Well, I mean, generally people kind of something to do, not just sit in the car, but
She.
I don't know. The walk is always a good thing. But, okay, so back to this though.
Just
When do I know that she's intoxicated with pills? How do I police that?
I'm reading the PC and the sign she was exhibiting that day is not what I'm seeing in court today. And I know that's almost impossible to police.
Yeah.
I have extreme concerns just like you. But as far as what I'm viewing here in the PC, it's not the same way I'm viewing this lady today, Judge. So, that being said, we need to have some way.
You and I both don't know where the dividing line is.
Correct.
Correct. It's like we're just a little bit pregnant. It's all or nothing.
Yes, sir.
Of course, you need to, if this is prescription and it's a viable medical need, I can't get in the way of that.
And she has expressed to me that she has serious mental health issues that she's working through, which is the basis for the prescription.
How long have you been on this medicine? How long? You just a ballpark.
3 years or.
Before that, were you on medicine like this?
On and off.
Not consistent.
It wasn't consistent until I got my diagnosis with my lupus, and that was for the Furoset, the Butybol.
Why did it take that long for them to find out lupus has a pretty distinct? I mean, you can test
to diagnose from what
It takes years to diagnose for lupus. Yes, sir.
It's a pretty
Look how fast
complicated.
this thing.
Autoimmune. It's an autoimmune disease.
I understand what it is, but it's diagnosable.
Yes, but I have also had friends and family that the diagnosis didn't come until after
All right.
years of testing.
But this benzodiazepines and it says barbiturates, which I don't know what that's a more of a generic term for that. I don't know what that is. What is your medicines? Let me see them. You have them on.
They're just a picture on my phone, Judge.
Picture on the phone.
I have emailed them to Ellie and Lacey.
You print them out and put them in the file, Judge.
Oh, she's on Facebook.
Facebook.
This is a Facebook.
Facebook.
I don't give
Reagan's
you,
Facebook
I don't give you
account.
permission to go on that Facebook.
Well, you got me on there now.
I would like to hand the phone over to one of our investigators,
I got a supper date tonight. That's good. That's good.
Y'all are making me red. Quit.
Okay.
There's another picture, Judge.
I do note from the.
Let me hold on for a second.
Yes, sir.
I've got two different physicians involved here, right?
Yes, sir.
Okay,
We'll print them out. Okay, yeah, do that.
Dr. Amal
That's my mental health physician.
and Dr. Wheeler.
That is my nurse practitioner. Yes, sir.
Is that your phone?
I'm so sorry. I thought it had it completely off.
So the initial lab report, Judge, did identify.
Hold on,
Yes, sir.
on the pantoprazole, that's going to be what, benzodiazepines?
That is my Protonix for my.
Which one is it tested
ulcer.
for, barbiturates or benzodiazepines?
Look, there's 3 pictures in total.
I
On
know,
the third picture is
pantoprazole, you're taking that.
Yes, sir.
Okay, how many pills do you get?
I take 1 a day
How many do you get in the,
and a 90-day supply.
you gotta renew it next month?
Yes, sir.
And then I have clonazepam.
Neither one of those would have had this lab result, which is at the time.
2 that are in the lab report are the issue.
When you're pointing, what are you pointing at?
It's not the clonazepam, it's the meth and the amphetamine that caused her issues.
The incident that we're here for today.
This is the toxicology
Oh, okay.
report from Austin that followed up after the initial
Okay,
results.
you see it again? Yes, thank you.
I could have jumped to that, Judge, but
Okay.
it's not in
Thanks.
the file, so I'm catching up with
Okay.
what's in there.
Because I thought,
Yes, sir.
yeah, I thought I heard something different.
You did, and that's what the initial lab result shows, but this is the more detailed exam that followed after that, Judge.
So she was on the prescriptions at the time, but the prescriptions were not the issue.
Yeah, it wasn't methamphetamine.
Correct.
That's what she tested positive for.
Yes,
Yeah,
sir.
for what test?
In the
Yeah.
lab reports,
Yeah, that's why the indictment came,
likely.
I presume. All right, so back to this, what do you want to do?
Maybe a drug patch, Judge, just to ensure that it stays with the amounts that we're dealing with and not illegal drugs.
Yeah, when do we come back, Name?
Lacey reset her, but her yellow sheet is in the back.
It's on the 14th.
November, October 14th, Judge.
What do you think about that?
I think that she is indigent, Judge, and she is already
I'm
putting the extra money that she has to the therapy that we've talked about. She's in counseling currently. She's in parent and child counseling with her son. She's working on the substance abuse counseling as well.
That's
all
that's
out of pocket
great,
for her.
but this is a preventative measure that protects us all, I think.
And her child.
Because she had a child at the time, and I mean, if
Just she's not driving currently. She
Still
does
has a
not
child.
operating any kind of.
still has a child, I'm a parent, I wouldn't have put my kids in that.
I think it's appropriate, Judge. I hate the expense, but I think it's the proper safeguard.
Well, look, if it's requested and there's good reason for it, I'm not gonna be the one, if something bad happens, well, if you'd have just followed my request, we could have prevented this. You're gonna have to have a drug patch as a condition of your bond.
Right.
Go ahead.
What is it, drug patch? I've never heard of it.
Probation office will, yeah,
Okay.
and what they do is they'll take it off periodically and test it, and the
It'll
secretion
Yes.
from your
And make sure that you're not using anything.
pores. If there's drugs in there, they secrete, and then we can test and see. And it's I think a wise thing in this case, but if the state requests it, they have good reason they have good cause to request it. And if I didn't, something bad happened, who's to blame is going to be on the front page, and
Yes,
it'll be that one. Let's
Understand.
just fix this problem and move on. You've never been in trouble before, have you, in the criminal system? You
I did
have?
get a DUI back 2007.
That was a
That was when I was a child.
passenger, Judge.
That was also the same?
It was the DWI with the child passing.
Okay. Okay, they're ahead of you in the line. You know that of importance. Your
Yes,
children are always in front. You gotta be exemplary and not put them in harm's way as well as yourself.
Understand.
You don't want too many times people are up here who do that, and a lot of weeping and crying goes on in that, especially if somebody gets injured or hurt or worse. Okay, next event
October 14th, it's already been reset
for,
in an outfit.
that's what we did today.
Yes.
But this is the real announcement next time.
Yes.
Okay, so resetting. Thank you. John?
Yes.
What do you have? Ty Cooley? Ty Cooley, come forward. 24 CR 749. Thank you. Your Ty Ethan Cooley, present with Mr. West, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes, sir, please.
In summary, this indictment alleges that on or about February 12th, 2024 in Jefferson County, Texas, you committed the third-degree felony of engaging in organized criminal activity by attempting to commit or committing theft of property, namely a motorcycle. Says burglary of a building, commit theft. You're not sure what the second paragraph is. It says consistent with effective consent to commit or commit theft of property, namely a motorcycle. And then the second part of it, burglary of a building with intent to commit theft, enter a building without the effective consent of the same person.
I think it's all part of the same paragraph, Your Honor. It's just it went to the next page.
All right. This is a state, a third-degree felony, correct? Which means you face no less than 2 nor more than 10 years confinement in prison, and a fine of $10,000 can be assessed. Do you understand?
Yes, Your Honor.
An agreement has been reached in your case where you would be pleading guilty, placed on deferred or unadjudicated probation up to 10 years in length. There's no fine, but restitution is going to be ordered in the amount of $8,699. Is that a 59?
Yes, Your Honor.
That was 46.
59 cents. Good luck with that. That 9.
It's 4,305.
You're still writing in Mayan, in the Mayan language. This looks like the Mayan, the 9.
It's me. Did not touch it, and that's how that came out.
We touch this thing and it all goes bizarre.
Usually it's my numbers that are funky, but in this case it's ours.
Yeah, you gotta write kind of like this.
Put something down on it.
Yeah.
Okay. Do you understand the plan?
Yes, sir.
When are you gonna be able to pay this restitution back? That means everything.
It's gonna be, I can't do it all at once.
It's okay.
I can do it over a time period of like.
Monthly, how much are you able to afford?
$100 a month.
That's gonna take 86 months.
I should do this probably. What's required for me to pay? What's required for me to pay monthly?
The quicker you pay, the better. But here's the deal: the people are out. I mean, if it takes you 5 years, they've lost the value of all that, and you're not being charged like some jurisdictions do, like the federal government, interest, a compounded interest. We don't do that, but it's the victims. To me, I'm sympathizing with the victims, and they go, "Hey, it took them 6 years. I got my money back, but dadgum, that was a 0 interest loan they got, and they were the wrongdoers." You need to pay as much as you can, as quick as you can.
Yes, sir.
And you're saying you can only do 100 right now?
I mean, that's just what I can come up with right now.
Right now, okay, what we'll do is the probation officer is gonna always, whoever it is going to keep ratcheting it up because it needs to get paid back as soon as possible.
Yes, sir.
That's what the answer is. How much that is and how long, it's different for every case.
Yes, sir.
If I follow this, you have no right of appeal. There is a fine of $500 as well. I'm gonna skip that. Can we do that?
Yeah, I don't know. That was not my office.
We're gonna skip that. No.
It was on there. It was someone else's office.
Oh, okay, okay.
But I'm fine not doing that.
That's fine with me. I just put it in there because that's what it was. I had written down.
Yeah, let's get the restitution paid to these
Sorry about
victims.
that. So that's fine.
All right, how do you plead in
Yes,
this?
sir. Sir,
Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty? Yes or no?
Yes, sir.
Okay. And also, I'm going to follow this agreement, which means you have no right of appeal of your case. Do you understand? You have to speak out.
Yes, sir.
Okay. Yes, she's got to take everything.
I apologize. That's okay.
Okay, I'll tell you what's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes, sir.
Understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection admitted. Among other things, this states you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, contemplation, cross-examination of witnesses, totally satisfied with the representation provided by the lawyer, all true so.
Yes, sir.
State's Exhibit 1, part of the record. Pre-sentence report is now waived.
Please, John.
I will follow this agreement and find that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. There's enough supporting from State's Exhibit 1, your guilty plea to find you guilty beyond a reasonable doubt. But I'm going to defer any finding of guilt and place you on deferred or unadjudicated probation for 10 years. There will be terms and conditions of probation that are normal and customary for this type of offense. You must pay restitution to the victims in this case who are listed in the indictment. And that is in the amount of $8,699.59. You must pay at least $100 per month. And again, at that rate, that's going to be 86 months.
So
that's 7 years. So quicker it gets paid, all things being the same, the quicker you get off probation.
Yes, sir.
Because I can release somebody from probation in a 1/3, 3 and a third years, but I won't do it if there's restitution. Okay. All right. So you understand what the game plan is.
Yes, sir.
All right. Anything else to add?
Okay.
If not, we're in recess on that. Thank you.
You can talk.
Okay, we're going to go back to Judge West, but I'm paused at the moment because I want to show you something. If you look towards the left in the back behind the people, there's a metal detector right at the entrance to her specific courtroom, and I can't say that I've ever seen that before, and I've never noticed it in her court before, but it's there. Normally you see them at like the entrance to the courthouse, and maybe they have it there too, and this is like a secondary measure. I don't know, but let me know in the chat if you've seen that before, but I've never noticed it in her court, and I can't say that I've ever seen it in another courtroom where it's right at the courtroom door. So I just found that unique. Anyways, let's get her rolling, and in just a moment the next contestant will come up, and we'll see what's going on with that.
All right, sir, you're Dalvius Williams. And Mr. Williams, in cause number 25 DCCR 0176, you're charged with a third-degree felony offense of injury to a child, and that's from October 28th of 2024. What that means is if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand? And I have here on the tablet a plea bargain rejection that you've signed with Mr. Rojas that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for a 4-year term in the institutional division. I'm assuming that would run concurrently with the time that you're currently serving. You have every right to reject that and have a jury here and decide your case. I just want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that? And do you want to reject that offer and have your case set for trial? I do want to make sure you understand, Mr. Williams, that after today, I will not accept this plea agreement. Once your case is on the trial docket, it'll go to trial, or you can change your mind and plea open to me or plea to something different, but it's not going to be this plea agreement. Do you understand? I just don't want you to think that you're going to sit in jail and things are going to get better somehow, right? Okay.
Judge, I would also like to put on the record that if he is rejecting this offer that would run CC, the state will file, have this, whatever he receives in this from the jury, to be stacked on top of what he's already received.
So I do want to make sure you understand, depending on the timeline of all that, there is the possibility that if you're found guilty in this case and whatever punishment you receive could be stacked or run consecutively to that sentence that you already received. Do you understand? And do you still want to reject that offer and have your case set for trial? Okay, we'll get that done. Mr. Williams, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him and appoint someone else today that could begin preparation for trial a little quicker. Is that okay with you? So, Mr. Rojas, you are released. Mr. Williams, we will appoint someone today, and they will begin preparation for trial. All right, you can get back with the bailiff. That may be one that we try to find a space for to get taken care of. He just wants to hang out in our jail. I said maybe try to get that done a little quicker. Just because I think he's, anyway.
Probably in his phone.
All right, let's continue with the Jefferson County ping pong. Judge Stevens has another contestant approaching.
In the matter of Christopher Reed Wyndham, that's you. Correct, sir?
I'm sorry.
You're Christopher Wyndham?
Yes.
Here, Mr. Gertz, your attorney and the state's attorney. This is in the matter of okay. Of the all around the subject matter concerning the Interstate Agreement on Detainers Act.
Yes.
And remember how this started. Was that a motion on your part?
Yes, Judge.
Defendant's motion to dismiss the indictment
Yes, Judge.
based upon this. Go ahead. Again, summarize your contention here for the record. Yeah, this and it's really two cause numbers.
Yeah.
Right, we have 24 CR 1937 and 1938. What happened on 1938?
They dismissed that one.
Okay, we're just at 1937, because that's the only file I have.
Filed and dismissed, but we're down to this one.
Yeah, okay.
Judge, the argument is a jurisdictional argument. And I don't have my file in front of me because I was just expecting to hear the court's ruling today. But the summary, I think, is that under the Detainers Act, for the Mr. Wyndham timely filed a request that his case be tried, essentially under the original 4 indictments. The state rightfully, I think, dismissed those indictments, but then turned around and indicted him for separate allegations, all stemming from the same situation, or at least the same complainant, the same defendant, the same weekend, the same what we would potentially call criminal episode. And so we've briefed the issue with the court several times. We've argued it several times, but it's our belief that the appropriate remedy is that the court does not have proper jurisdiction over him, personal jurisdiction, kind of going back to civil procedure world, personal jurisdiction over him, because he should have been this whole time back in federal.
Doggone it, Judge. Stop doing me like that. All right. Back to Judge West.
Ross, in cause number 24, DCCR 1198, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation December 18th of 2024 for the offense of deadly weapon in a penal institution, a 3rd-degree felony. And that was a deferred probation for 4 years. Is that correct?
Yes, ma'am.
It alleges that you, I'm sorry. And then I also have cause number 24, DCCR 1199. Also a motion to revoke your unadjudicated probation. This shows that you were placed on probation December 18th of 2024 for evading arrest or detention with a motor vehicle, a third-degree felony, and that was also a 4-year deferred probation. Is that correct?
Yes, ma'am.
Tell me again why we're doing this.
Judge, DPS did bring the video in. They have yet to submit the case formally to be indicted on the evading. So our thought was to allow that to come in, maybe hold it, see how he participates in ISF. Certainly if based on the circumstances we need to rediscuss it, we can. I don't believe he's had any write-ups while he's been in. I mean, obviously the new offense was quite egregious.
Well, and that's my, if you're on probation for that and then you do it again. 6 months after you were placed on probation?
No, I would only ask to let him go. That charge is still out there. And then we can address it depending on what the court wants to do, or we come in front of the court again.
But if he pleads on it now, then I don't think even if it's indicted, I mean, if he pleads true today to the new offense, and I do what I do on these motions and reinstate and send them to ISF, if the case is then submitted, or when it's submitted, you can't allege the same thing again and then me re-punish him for the same offense that he's already.
It's the new offense that you would address.
But y'all said that today. Count 1 is the new offense.
Right, but
I can't do it twice.
Well, once it comes back, once it gets indicted, then it can be addressed.
On its own abstinence.
Yeah, on that, not the NTRP, but the new offense.
Well, I know, but then we have 2 probations and a new offense, and the argument then is going to be, we'll leave him on probation because you can't revoke him because you already did this. Because I already took it into consideration on these motions.
Of leaving him on probation and then sending him to the penitentiary if he doesn't do well on the new offense. See what I'm saying?
I know, but that's just, I mean,
Would you
any
prefer,
word
Judge,
on
that I
where
just-
that is,
that I
why
just
they're,
reach out to them again? I know last time it was kind of in the context of that conversation. If you
Yeah.
don't want me to call them, you're gonna call them.
Yeah.
I can do that, and I can get it to grand jury by next Wednesday.
I just would like more information, I think, before, on that case. I don't think we need to have them on a probation, and then those out there pending, and then in the middle of ISF, they send it. If a warrant's issued, they're gonna kick them out of ISF anyway.
They were gonna hold it until he got out, Judge.
I'm gonna reset it just a short time. If you will reach out, or if I need to reach out, I understand, I appreciate that they, I guess, cooperated somewhat with getting the video, but I think I'm gonna look into that a little more myself and find out where it is in the process and why it has not been submitted.
Because the offense date is June 13th.
Yeah, that it makes no sense to me. And from what I recall, it was not just a couple of blocks going slow. It was, okay.
I'll have investigator Bates reach out this morning, and we'll get it indicted by next week. If maybe an update would be beneficial.
That's what I'm thinking. I think I'm not gonna just automatically do it. I think if there's gonna be pleas, we can do an updated PSI. I wanna know more about everything that's been going on before I agree to something like this. All right, you can go back with the bailiff. Would you put a sticky on that for me to contact?
All right, let's go a couple miles east and see what's going on with the parole board in the great state of Louisiana.
Today is Tuesday, September 9th, 2025. The time is 9:30 a.m. My name is Cheryl Renaud. I'm serving as chairman of today's panel. My colleagues on the panel this morning, seated to my left is Mr. Danny Byra, and to my right is Mr. Pete Freeman. We're situated at DOC headquarters in Baton Rouge. So I'd like to get the staff here to introduce yourself for the record, please.
Francis Abbott.
All right, thank you. And our first remote location this morning is at the State Police Barracks. Good morning, Captain. Would you and any staff you have there introduce yourself for the record?
Good morning, everyone. Pat Washington. No other staff, just me.
All right. Well, thanks for accommodating us this morning. And we have Mr. Ritchie there with you. Mr. Ritchie, would you introduce yourself? Tell us your name and DOC number.
Yes, ma'am. My name is Mark Ritchie. My DOC number is 304375.
And let me, before we get started, Mr. Ritchie, I want to acknowledge the folks who have joined us today here with us in Baton Rouge. Well, we have counsel here with you this morning. Counsel, would you introduce yourself for the record?
I'm Hannah Rose Brodell, an attorney with the Parole Project representing Mark Ritchie.
Thank you. We have your son, Alex Ritchie, Eric Ritchie, another son, Laura Ritchie, William Sharp, Caitlin Sandiford, Mark Ritchie, Imani Diaz with the Parole Project, Chris Hernandez, and then by Zoom, we have Perry Stagg and Kerry Myers with the Parole Project. So first, Mr. Ritchie, I'm going to read some identifying information into the record and ask you to confirm it. And then we would like to get your statement first. We'll hear from the captain. We'll hear from the folks who will be speaking today. And then Mr. Freeman will be conducting the parole interview with you. You ready?
Yes, ma'am.
Mr. Ritchie, you're classified as a third felony offender. You're currently serving a 45-year sentence. You were sentenced in Ouachita Parish in July of 2007. 1 count of attempted armed robbery and 3 counts of armed robbery. You have a parole eligibility date, which is on November 2nd of this year. You have a good time release date in February 7th, 2043. Does all that sound correct?
Yes, ma'am.
So before we hear from your speakers, tell us this morning, tell us a little bit about how you got to jail and why do you think we ought to vote favorably for an early release?
Yes, ma'am. Thank you. First, I would like to say that I'm very sorry to the victims of my crimes, Mr. Grover Smith, Miss Kaylee Bordelon, and Miss Glenda Sanderlin. To their families and to everyone that I have harmed with my thoughtless and selfish actions, the extent of harm I have caused far exceeds what I'm in prison for. My selfishness and my thoughtless actions have cut a path of destruction across many lives. I live every day with the regret of knowing that I was the cause of so much harm and trauma to my victims and their families and to everyone else around them. I'm in prison for committing 2 armed robberies and attempting a third. At the time, I had recently been laid off from my job and I was unemployed. I felt like a complete failure because I could no longer provide for my wife and children. While I had experimented with drugs in the past, my recent introduction to crack cocaine compounded my inability to cope with my financial hardships and my sense of worthlessness, and this led to a series of harmful and deeply troubling decisions. In October of 2005, I purchased a BB gun and a Halloween mask, and in a fog of intoxication and desperation, I decided to rob a store called the Red Door. At the door, I put on the mask and pulled out the BB gun, which looked very much like a real gun. I rushed through the door to the counter and I demanded that the young lady behind the counter give me the money in the cash register. She was in shock and not responding, so I went around the counter and demanded that she open the cash register for me. which she then did. I took the money from the cash register and I left. This young lady, Miss Kylie Bordelon, was in the store alone that night, and I am so sorry for the fear and pain that I caused her. The second armed robbery was also at the Red Door. It was identical to the first, except there were 2 women in the store that night. I used the same mask and same BB gun, and I rushed through the door into the counter and demanded that the women give me the money. And I took the money and I left the store. These 2 ladies, Miss Kylie Bordelon and Miss Glenda Sanderlin, were working to make a living, and I robbed them of more than just money. I took their peace, their safety, and their sense of security, things that I know I can never give back. The fact that Miss Bordelon was present at both robberies deepens my sense of guilt and shame, which is no more than what I deserve. I pray that both Miss Bordelon and Miss Sanderlin have managed to heal and have found the peace and sense of security that they deserve in spite of what I did to them. No one deserves to be frightened and terrorized the way they were by me. I also tried to rob Mr. Grover Smith. He was at the boat launch at Shinny Lake in West Monroe. I happened to be driving by when I spotted him out there alone. I parked my car a distance away from him and approached on foot. His back was to me when I walked up to him and said, "Excuse me, sir." And I could tell by the look on his face when he turned to see me that he was shocked and frightened. He happened to be on his phone and told whomever he was talking to dial 911. I demanded that Mr. Smith give me his money. And while my actions were intimidating and threatening, he made it very clear that he was not going to comply with my selfish demands, and I walked away. To this day, I am impressed by his courage and bravery in the face of my thoughtless and desperate behavior. Not too long after this, I was arrested and taken to jail. And after a few days in jail, my mind began to clear and I realized how far out of control my addiction had taken me. The thought of the things that I did and the thought of the consequences my family would have to suffer were just too much to bear. And I decided to take responsibility for my actions, and I became determined to take whatever steps I needed to take to change. I knew the first step that I had to take was to take responsibility and ownership of all the terrible things that I did. I made statements to the police and confessed to everything that I did. I've had a lot of time to think about the things that I did, and I know that I was wrong. The harm that I caused drives me to stay sober and live my life in service to the people around me. I knew I had done terrible things, and the guilt and shame set in. Excuse me. I've been incarcerated for 20 years and have been sober through it all. I've worked very hard to address the issues that caused my addiction in the first place, including Christian counseling, therapy, and therapy from peer mentor graduates from the Bible College at Angola. I've consistently participated in and facilitated substance abuse programs such as AA, NA, and Celebrate Recovery. I've learned to love and cherish my sobriety, and I work to maintain it through accountability and continued participation in these programs. I learned to be a better father through Malachi Dads and Returning Hearts. I learned to be more compassionate, empathetic, and thoughtful about how my actions impact everyone around me through victim awareness and anger management classes. It is only by the grace of God that I am before you today, and I am asking you for just one more chance. Please consider granting me the opportunity to finish out my sentence on parole. I now know that because of the programs that I've been exposed to and the things that I've learned, that I have a lot to offer. And I wish to give back to the community that I took so much from. Again, I wish to say that I am so very sorry to Mr. Grover Smith, Miss Kylie Bordelon, and Miss Glenda Sanderlin. To their families and communities, to my wife and children, and to my community, my actions altered the course of so many lives, and the guilt and shame will haunt me forever. I can never make up for the crimes I committed against my victims, and I pray that they have found healing, peace, and comfort in their lives in spite of what I did to them. I wish to thank this board for taking the time to hear this matter, and I also wish to thank the countless people I have encountered over the past 20 years who took notice of my potential and guided me and allowed me to use my gifts and talents to make the transformation necessary to become a better man and affect positive change in the people around me. I express my remorse not by what I say, but by how I choose to live my life. I pray that you can see I've changed and that you will have mercy on me. Thank you.
All right, well, thank you, and thank you for being prepared today. You put a lot of thought into that.
Yes, ma'am.
Well done. Captain, what can you tell us about Mr. Rich?
Mark's been here for 11 years. He's part of our maintenance team. In that time, I know community service is a big deal, and he's been a very big part of this community. He's a master electrician, so anytime we have, and y'all have been here, so you know we have power outages pretty regularly because we're in a very rural area. Mark is one of the people we call. Any kind of disaster relief that we have to get done, Mark is one of the people we call. He's been a part of every major project and renovation we've had here because he is our lead electrician. Actually, the only one we have classified as an electrician. So anytime that any work has to be done here, he does it. From simple things like working on generators to recently he rewired the entire inmate canteen and he hooked up our generator to do the automatic transfer when the power goes out. He's also been a part of the worship team on and off. He's a musician as well. Just all around a good hand to have around. Thank y'all.
Thank you. All right, so we'll hear from the folks who want to speak on your behalf. First, Mr. Stagg, could we hear from you?
Good morning. Can you hear me?
Yes. Yes.
So I've known Mark since about 2010, I think. When we originally started the Corrections Court Reentry program at Angola, Mark was one of the original vocational mentors that we tapped to help lead that program. The reason being, just like the captain just mentioned, Mark is a master electrician. He's a very talented electrician. Mark had continuously shown great moral character. We were very comfortable putting him around the young men in the program, knowing that he would, lead by example by his actions. Mark became very passionate about teaching. I'm not sure if he'd ever taught anything before that. We simply were impressed enough with his talent and his character to, ask him to be a part of the program and teach these young men. But he became very impassioned about teaching and really showed a lot of care and concern for the young men that he had in his program. A lot of the guys that went through Mark's class became electricians as well. They released, they went to the street, and they're being very successful now. And a lot of that is due to Mark's teaching and the character he displayed and demonstrated every day. I've still call on Mark from time to time. If I have a problem with a generator or a lawnmower, I'll drive out to State Police Barracks and go see Mark and get some advice or a little help on how to fix it. And so I've stayed in contact with Mark for all these years. He's a good guy. Has never given anyone a problem. Just like the captain said, when he was at Angola, he was always part of every special project we did. He was the first one to volunteer and step up. Just couldn't ask for a better guy to have around when you need something. So that's my opinion of Mark, and I hope y'all see fit to give him an opportunity.
Well, thank you for taking the time to speak to us this morning. We appreciate your input.
Mm-hmm.
Here with us, we have Eric. Eric, you want to step up to the podium, please? And then just tell us what you'd like us to know.
Good morning. My name is Eric Ritchie, 1 4 Finley. Stand before you today respectfully request on behalf of myself and my family. Can you please grant my dad Mark Ritchie parole? My dad is a wonderful person. Feel so fortunate for the relationship that we have, even though he wasn't always physically there. I always felt that I had a father figure. They always made sure to teach us values of integrity and respect. 26 now, from as young as 12 years old, I've been with him nearly every weekend. He's always been a good, very friend father. Feel so lucky that we had the opportunity to do father and son things that parents for our family to be like on the outside. I'm so grateful to my mom and her dedication to making sure that we could always be with them. I'm not gonna lie and say that there haven't been a void from physical separation with him, because there has been. Himself emotionally, there's been a loss of love, affection in my life. There's missing him. I've been there. There's been a lot of financial hurdles for ourselves at home. And it was tough to become the man of the house in some ways. But our parents always made sure that we had what we needed. Even though he was separated from us, he still managed to do a good job parenting us. I remember many times going to visit my dad, and I would have things to talk with him about, struggles at work, different things in life that I didn't feel were going well. And he always was there to guide us through. At the in between times were hard, but it was always so helpful to be able to have the experience to talk to him. The thing about my dad is he didn't always tell me what I wanted to hear, but he told me what I needed to hear. I've learned so much from my dad over the years. Really admire him, and without his guidance, I can imagine what an absence like this would do to a young man like me. There are many possible negative outcomes that could have happened. I'm proud to say that my siblings and I are all sober, functioning members of society. We have positive influences around us. We have a strong community and support network, love of each other, and unwavering faith in God. My siblings have always had significant others and relationships, but it's been a personal struggle for me because I've always wanted my dad to be present for that part of my life. And now that work is slowing down, I can be less career focused and met my fiance, someone who had values and goals that were along with mine. It would mean everything to have him at my wedding. He didn't have the opportunity to see us graduate high school or the electrical program, 3 times with electricians as well. It's some of the proudest moments. We were always able to make up for that lost time here in business and sharing that with him through photos. But it was hard to look around and see him not there physically. And for my wedding, big moments moving forward, I wanted him there. And not having him around is why it's kind of taken too long to get to this point. When I was in school, my dad shared with me how he became an electrician, and I was very influenced by that. I didn't always feel like a college-oriented person. I wanted to use the opportunity to support my family financially. So I decided to pursue the same electrical apprenticeship program that my dad did. And when I went to go pick up the orientation materials for the apprenticeship, there's a photo of my dad on the fridge. I realized how big of an impression he made. I've been working for that company, coaching lectures for 8 years now. And when I went in for my initial interview, the boss of the company, Mr. Chad Copeland, asked me one question. He said, "Who's your dad?" I said, "Mark Ritchie." I've been working there ever since. So, my dad laid this professional path down for me, and it would be the greatest gift of my life to be able to work with him alongside him. Training my father for role would not only reunite family, it has held strong over 20 years of separation. It would give him the opportunity to continue contributing meaningfully to our lives and our community. He never stopped being our dad, our mentor, and our moral compass, even from behind bars. We are ready for him to be present, not just in spirit, but in person. I want him to attend the wedding. I want to build a future where my children know their grandfather, not just through stories and visits, but through real shared life. My family's ready. I'm ready. Most importantly, I truly believe that my dad is ready. And on behalf of myself and everyone who loves him, I respectfully and humbly ask that you please grant my father, Mark Ritchie, a chance to come home. Thank you so much for your time.
You did a really good job representing the family. And so the parole project, Mr. Myers.
Good morning, Kerry Myers with Louisiana Parole Project. I'm not going to take up the board's time this morning. Mr. Ritchie is an excellent candidate. We've known him for a number of years. We're prepared to provide him with the transitional services that he needs upon reentry. He has a strong support system. He has employment ready. Mr. Ritchie is a perfect example of what corrections can do. The opportunities were there. He took advantage of them. He went beyond that, taking advantage of them. We believe Mr. Ritchie is an excellent candidate. Addiction can destroy lives. Addictions can also be overcome with the work. Mr. Ritchie has proven that. He's a success story, and we ask this board to grant his release today to Parole Project and to his long-term plan.
All right, thank you. And Ms. Bertle, we'd like to hear from you.
Good morning. My name is Hannah Rose Rodell. I'm an attorney at the Louisiana Parole Project, and I'm here on behalf of Mark Ritchie, who this board can see is a model of true rehabilitation. A man who has paid his debt to society, fully transformed himself by addressing the causes of his crime, and fulfilled the goals of our correctional system. As you've heard from Mark, his crimes were the result of poor decision-making, substance abuse, and trauma, all of which he's worked tirelessly to address ever since. And since he spoke about the nature and details of his crimes so well, I'd like to use my time to highlight some of his accomplishments. In 20 years, Mark has not received a single disciplinary infraction. This alone is extraordinary. But his growth and transformation go far beyond institutional confinement. For the past 11 years, he's held a placement at the Louisiana State Police Barracks, an honor reserved for less than 1% of the prison population. A position not freely given, but earned through trust, character, and conduct. When I first asked Captain Washington what he could tell me about Mark Ritchie, he said, "He's the hardest working person I've ever met, and you can't have him." Mark came to prison as a licensed electrician, but he didn't stop there. He went on to become a master electrician, skilled carpenter, and a maintenance trustee. Mark voluntarily remains on call 24 hours a day, where he is relied upon for everything from storm response to urgent repairs and electrical work at the governor's mansion. Chris Hernandez was here today to show his support. He supervises Mark in his daily work, and he told me that Mark has surpassed him in vocational education and expertise. Mark has also maintained something equally powerful: his role as a husband and father. Over the last 2 decades, Mark has maintained his loving and supportive marriage with his wife Laura and close relationships with their 4 children. Despite the distance, Mark has stayed engaged through regular visits, phone calls, and guidance. Today, all 3 of Mark's sons work as electricians, following in the professional footsteps that he laid. And Mark has secured himself a job opportunity to join them and work at Copeland Electric full-time on his release. Mark's impact doesn't stop with his family. He has taught and mentored hundreds of trainees, teaching them vocational skills and trades, but also instilling in them a sense of dignity, purpose, and hope. Jeremy Burns, a retired lieutenant and executive officer, submitted a letter in your material before you, and he said, "Mark was exemplary to say the least." His most impressive character trait is his kindness and willingness to help others, even when not in his best interest. He has shown that whatever journey he's on, he'll be the best example, not just for himself, but to those lucky enough to know him, and I have no doubt an asset to whatever community he's a part of. Mark has also addressed his past struggles with substance abuse. He's been sober since his arrest, pursuing, participating in, and facilitating every recovery program available long before he ever imagined parole would be a possibility for him. He and Laura are both facilitators to Celebrate Recovery, and we look forward to continuing that work on the outside. Taken individually, any one of these facts is extraordinary, but together they tell a fuller story. They tell a story of a man who built a life of integrity behind prison walls, not just by focusing on himself, but through service to others. I have been deeply moved by the outpouring, the overwhelming support Mark has received from staff, supervisors, peers, and loved ones. Each person I talked to spoke not just of his work ethic, but of his character. I've been equally moved by Mark's words and work, the genuine remorse he feels for the harm he caused, and in many ways, that remorse fueled his quiet but steady commitment to change. Mark's life is a living example of what faith through service looks like, and what redemption can truly mean. With the full support and services of the Louisiana Parole Project, and steadfast love of his family, Mark appears before you today fully prepared for a safe, meaningful, and successful re-entry. We hope and pray that this board can see Mark for who he truly is, an extraordinary example of the mission of corrections and parole. For these reasons, and for the reasons more fully outlined in the materials submitted to you, we respectfully request the board grant Mark's parole and release him to the Parole Project. Thank you very much for your time.
We also have here green cards from Ms. Chris Hernandez, and he says he worked with Mr. Ritchie for 12 years at DPS. He was respectful and cautious, always at work, never sick. I was able to let Mark work freely as he is the master electrician, a mentor to me at 57. And also William Sharp, friend. I've known Mark since 2014. I worked at the barracks as a police officer at DPS. I saw Mark almost daily on the job. He was never any trouble and always ready to help. I truly believe he deserves a second chance. Mr. Ritchie, the case has been assigned to Mr. Freeman. Would you answer any questions he has?
Good morning, Richard. So how long have you served on this charge?
20 years, sir.
Okay. And I thought it was a mistake, but obviously it's not. You have not had any disciplinary write-ups for 20 years.
Never.
No. That's pretty extraordinary. I just want to tell you that. I think you took a lot of classes. What class you took that affected you the most?
I would have to say, if I had to pick one, I would say the reentry, my involvement in the reentry program had the most to do with really changing everything about my character. Because with my involvement in the reentry program, it opened up doors for me to take all the other classes that I was able to take, including Celebrate Recovery. I learned through the reentry program to be selfless in my actions and put other people's wants and needs in front of my own. And with that, it really just changed everything about who I am, because I had an opportunity to take young men who never had a chance in life and shepherd them and give them the support and encouragement that I never had as a child growing up. And then my access to Celebrate Recovery and the substance abuse programs that I had access to, being at, I was allowed to first take these programs and then start facilitating them. So I was able to help other young men who had substance abuse issues with with their recovery, which in turn increased my recovery. I really just learned to be a giving person instead of being selfish.
Okay, and the substance abuse, that was another thing that had kind of caught my eye. Do you think you need any more substance abuse, any long-term substance abuse? Do you think that would help?
Whether I need it or not, I plan to continue with Celebrate Recovery. I mean, it's really that is a church-based recovery program, and the church that I'll be going to has a Celebrate Recovery program, and that's just going to be part of my everyday life. Whether I'm participating or facilitating Celebrate Recovery, I will have active involvement in substance abuse from now on.
Okay, and you're gonna go to work for Copeland Electric, am I correct?
Yes, sir.
And, no, I do want to compliment you. I mean, you're very prepared today. You mentioned all the victims by name, which is very important because, you know, that's the reason we're here.
Yes, sir.
I don't have any more questions.
I don't have any questions.
I have no questions. I think we're prepared to vote. You ready, Mr. Mr. Freeman?
Yes, I'm gonna tell you, your family was very impressive, and you've done a good job raising those boys. Even though you wasn't there personally, it looks like they've all turned out well. My vote today is going to be to grant.
Thank you.
With special conditions that you get nowhere around Miss Bartalone, Mr. Grover, or Miss Sanderlin.
Yes, sir.
You're not to go anywhere around them. I don't want you living around them. Let's live at least 10, 15 miles away from them. I don't want them to have that in their face. But other than that, I also recommend 2 AA meetings a week, which I don't think would be any problem for you. And I think that's really basically all you need. So that's my vote today.
Mr. Byron?
I'm going to concur with Mr. Freeman and vote to grant you parole today based on your behavior in prison, the letters of support that you have. I think you wrote some very good victim accountability letters, which I don't see very many of those. Those were impressive also. And good luck to you.
Thank you.
All right, Mr. Ritchie, I do agree. My vote also is to grant. My decision is based on all those factors, the positive, strong support you have from the facility staff. You have an excellent prison record. I will stipulate that you do follow or go through the parole project transition plan with the same special conditions, no contact with the victims. Thank you for the hard work that you've done, and congratulations.
Thank you so much. Thank you.
Approved?
Thank y'all.
You know, for once, I actually bought into every word that was said there. I really did. Which, you know, we don't often see. There was no excuses. There was no cloaking himself in all of the good things that he's found. There was none of that. There was taking accountability, and here's all of the things that I have legitimately done to better myself. And good on him. I honestly hope this guy does well on the outside. I really do, because, again, how often do we see something that genuine and something that meaningful? Not often out of there. Ashley just put in the chat it was real. I totally agree. Totally real, which, you know, is rare. But, you know, I show a lot of these hearings for their human perspective. And this is a guy who made a lot of mistakes, but has seemingly worked hard to fix himself and atone for it. So, again, good on him. Let's go to Judge McNally with a guy with a very bright shirt.
Lisa, I don't know who gets this case.
I guess it probably goes to me. Your name?
Joshua Michael.
Where you been? You're supposed to be here a year ago.
I understand that, sir. I'm not gonna make any excuses for that. Right now, currently, I'm in a Monroe County Circuit Court Drug Court with, Judge Nichols. I also have a letter from.
Oh, okay.
Your Honor, I put a copy of the letter in the file. That's for the court to keep and review. Last October, when my client had his court date, he was using, and he makes no excuses for that. But he's been in drug treatment court, as the court can see through that letter, since March. He anticipates that to continue until next July. And looking at the letter, he's doing really well.
Okay, good enough.
The court coordinator signed it. This offense was 2 years ago. He obviously needs to have it adjudicated and continue his good work in down in Monroe with Thursday.
All right. I don't believe he ever was printed on this case.
No, sir.
Why didn't you go and get printed? Somebody signed the order.
I'm not gonna make excuses, but I live down in Monroe and it was a problem for me to get a ride. But right now, I'm working with GROFF, which is a recovery advocacy warriors, and they provide transportation. And that's who actually brought me here today.
Lisa, I'm gonna need an order for prints. I need a new bond sheet. How long you been in their drug court?
Since March.
Why didn't you come in here earlier?
No excuse. I knew I had the warrant.
Didn't they tell you to come in here?
They did. That's why I'm here today.
Well, it was March.
Yeah. It was.
I swear, I think we're operating a five-star restaurant here some things.
Your Honor, as my client indicated, he can't get a ride, and he got a ride from, it's called Recovery Advocacy Warriors. They provided ride service for him here today.
I don't want to hear about rides. I get so tired of hearing about rides. They don't have a ride. They had a ride to get here. They lived here. But all of a sudden, the whole criminal justice system's worried about rides. They don't have to get a ride to court. They don't have to. Jeez. Lisa, print out me another. I'm going to give you a $10,000 personal bond. Lisa, print me out another order. You have to go over and get fingerprinted and photographed today. Do you understand that, sir?
Yes.
By 2 p.m. at the Michigan State Police Post. Was this a Taylor case out of the Taylor Post Council? Do you know?
It was right.
So you have to go over there today, defendant to comply, not to consume alcohol, marijuana, or illegal drugs, to comply with all terms and conditions of Monroe Drug Court, okay?
Yes, sir.
If you weren't in there, you'd be sitting in jail probably. You can't do this.
I understand, sir.
All right. So that's what I'll do. We're going to give you an order for prints. You're going to take that order over there. Do not leave until you get it. I will give you a new court date. We will give you a pretrial date on September.
How long do you want to go?
23rd is good.
All right, 23rd at 9:30.
Okay. And then just send down the order for prints if you can, or give it to John and I'll sign it, okay? So you have to go over there. Don't leave until I give you the order for prints in the bond sheet, okay? Any questions?
No, sir.
If you want a lawyer going forward, you fill out a petition for a court-appointed lawyer, all right?
Yes, sir. All right, might have done it before in October.
A year ago, I know, but this is 25, September of 25. It's 11 months later. You might have hit the lottery. I don't know which. All right, that's what I'm doing. Good luck. Thank you.
Yes, sir. I appreciate it.
What are you laughing about?
Those are highly portions.
All right. What else do we have here? Did they get a hold of Detective Strong or Officer Trooper Strong? Brown, rather.
Carl said he's got a boatload of stuff in front of Judge McMahon or Judge Best.
Scheduled a bunch of stuff today. I don't know how long it's gonna be.
Why am I? Ma'am, I can either reschedule this. Come on back up here. Robin Michelle Barnett, 25M549-453. Your name?
Robin M. Barnett.
So, I mean, what's fair is fair. I know you had an excuse. I'm setting aside the default judgment. But I can't dismiss it. He's in another court. If you want, I mean, he's next door. If you can either wait or I'll reschedule it in a week or two and let you.
Would like to.
No, it doesn't matter to me. It's more your convenience. I'm here either way. If you want to wait, fine. If you don't, I understand. You've been here for an hour and I'll be glad to reschedule it in a week or two.
If I can wait, if it's not,
I don't know how long it's gonna be.
schedule.
Don't worry about me. Don't worry about me. Okay? I'm fine with it. I just hate to see you wait. It sounds like he's got a boatload of them over there, okay?
Okay.
So it might be a while. So, all right, have a seat, and as soon as he's ready, I'll call it, okay? Thank you.
Can I ask if it would be a problem if I did a little work on my cell phone if there's no volume on it?
No problem.
Okay.
Thank you for asking. Most bring in cell phones, don't bother turning them down, and they're disruptive. No problem.
All right, while he figures out what's going on in his world, we'll go back to Judge West.
Good morning. Are you Trustee Butcher? Yes, ma'am. And this is cause numbers 24 DCCR 1732 and 24 DCCR 1733. Ms. Butcher is on probation in each of those cases. One for burglary of a habitation, which was a 5-year deferred, and also an unauthorized use of a vehicle. And there were motions to adjudicate filed in each of those cases. And Ms. Butcher was previously here, pled true to counts 1, 4, 5, 6, and 7. I've received the updated report. This was not agreed. Has everyone received that and reviewed the report?
We have, Your Honor. Yes, Judge.
Are there any additions or corrections?
No, Your Honor. Not from this.
And what is this, it might say here? The new case is out of Harris County.
She was placed on
Probation, right?
probation and sent to the Santa Maria Rehabilitation Facility.
Okay. All right. So, Mr. Rojas, you may proceed.
Thank you, Judge. And that's true, Judge. She was sent to Santa Maria through probation at Harris County. And as the PSI points, or the updated PSI points out, she left that facility. I spoke with her about that. She left that facility because there were open warrants out of Jefferson County. She wanted to take care of those warrants. Not because she didn't want the help provided there. She tells me she does want to go back to the Santa Maria facility. And there they will help. She's got a 3-year-old son, in addition to being 6 months pregnant right now. And the facility is a facility that will allow her to bring her 3-year-old with her, as well as she will keep the newborn once that newborn is she's giving birth. And she does want the help that Santa Maria can provide, and she's willing to go back there. And that's what she wants the newborn to be once he's born, or she is born. As far as what she wants to do with her life, she told me she was working in the healthcare industry in the past, and she wants to go get her CNA licensing, and she wants to continue doing that when she gets out. She does have a letter she wants to read to you, Judge, and I think if this is the appropriate time, she wants to do that.
Okay, go ahead.
Dear Honor, I have been in jail since April 29, 2025. I left the rehab because I wanted to come back here and turn myself in.
Let me just stop you real quick right there, because the officer called Santa Maria, and the people at Santa Maria, according to what that officer put in this report, said that you left the facility because you changed your mind.
I did not.
Hang on. Quote, Santa Maria is not the best option for me at this time. Are you saying you did not say
I
that?
did not say that. She know why I left because I had a warrant for my arrest and I didn't want the police to pick me up. I couldn't go to the DPS and get my ID and stuff, so I was gonna come back to Port Arthur, turn myself in, and then go from there. But I didn't leave because I didn't want the help. That's why I found out I was pregnant on March 31st. I found out I was pregnant. I was in that rehab. I left because they wanted me to go to get my ID and I couldn't go there because I had a warrant out for my arrest.
Okay, so you found out you were pregnant in March.
Yes.
And then you went and committed an evading arrest with a vehicle, a duty on striking an unattended vehicle, and an aggravated assault against a public servant a month later after you found out you were pregnant?
I was on drugs, Your Honor.
While you were pregnant?
Yeah, I made the mistake of leaving the rehab and I got on drugs and the next few days later I got arrested.
But you said you made the mistake of leaving the rehab, but you said you left the rehab to come and turn yourself
Yeah.
in. So
So
you
I
didn't
bought
leave the
a
hang on. So you didn't leave the rehab to come turn yourself in, because if you had, you would have come straight here and turned yourself in and you wouldn't have these new
I had to
offenses.
catch the bus, so I had to go downtown, wait for the bus to come, and in that time, I caught a charge. I don't want to be separated from my baby, Your Honor. This is my.
So in that time, hold on. So you had left the facility at least by April 17th.
Yes,
And then your new charges were April 29th.
yes,
So that's 12 days
Yes.
of waiting on a bus and catching a
I
charge?
didn't have the money, so I got the money together to catch the bus back out here, the Greyhound. And once I got the money, the day I was going downtown, I got arrested for trying to evade the police because I was on drugs. I was scared and I was on drugs.
So all the times that you failed to report to the probation office, March 7th, March 10th, hold on, there was a third one,
March 12th.
March 12th, April 10th.
I
So
never knew I had all those dates after the 7th. After the 7th, I thought I was revoked already. After the first time I did report, I thought I had a warrant out for my arrest, and I went to the rehab.
but you talked to the probation officer
I
between
talked to
then,
her on the 7th.
and you
day.
talked to her ugly.
I got out of jail in March 6th in Harris County.
Mhm.
I called her that day.
Mm-hmm.
She wanted me to report the next day. I couldn't make it.
Right.
So I guess I talked to her within that week. I don't remember talking to her, but I didn't know that she was giving me more opportunities to report. I would have reported. I thought after the first time that was it.
The reason you probably don't remember all that is because I guess you were using drugs while you were pregnant.
Yes, ma'am.
Yeah,
I didn't know I was pregnant at first, and then I found out.
but then you kept
And I-
using drugs.
Yeah. I need help, and Santa Maria is a good place, and they'll offer me mental health service, and I have an autoimmune disease that they offer treatment for. Jefferson County hasn't been giving me the medication for it. And since I've been here 52 days, they haven't given me any medication, so my baby can, yeah. I don't wanna say it out loud what it is, but, I need the help that Santa Maria offers. I don't wanna be separated from my kids any longer. My 3-year-old is with somebody, a friend, and I want him to be able to come with me. I just want to be able to keep my kids with me and get the help I need mentally and with the drugs.
So where do you actually live?
I live on 1825 17th Street,
What city?
Port Arthur.
So Santa Maria is what, 90 days?
It's up to 6 months to 18 months.
It was verified through the Harris County Community Supervision Court Liaison that the program is 6 months.
Yeah.
So where did you get the 6 months to 18 months?
They told me at San Maria when I was there, it's up to, you can stay up to 18 months.
Mr. Smith?
Judge, I spoke with Misty Hoffman, who's an assistant DA in Harris County, before they sent her to the Santa Maria program. They were thinking about doing that, and she tried to explain to me what it was, and I explained to her. Our intention was not to keep her on probation, it was to seek a revocation in this case. I think everything that she has said up to this point kind of lends credence to the fact that probation is, she's not going to be successful on probation. I think even today, you can see that she gets, according to the PSI, becomes impatient, easily irritated, argumentative, and confrontational. She's been non-compliant basically since she started in on probation and has made no progress and has no plan. This is the first that we've heard that she even has a residence in Port Arthur. We had no idea that she had any kind of residence in Jefferson County. She didn't have one prior to this, so I don't even know whose house this is.
So here's the thing.
Yes, ma'am.
Talking over people,
Sorry.
being confrontational with your probation officer is not going to get you anywhere. Right?
Yes, ma'am.
So if you have, what's the place in Port Arthur that you have to live?
It's a home. It's a house.
Whose house?
It's my house. I've been renting it.
Since when?
Since before I got on rehab, I've been using the same address.
Well, but you've
Before I got
told,
probation.
but you told probation that you didn't come back here, hold on, because you were homeless.
I've never been homeless, ma'am.
You said that in the original pre-sentence report.
No, I told her I was at a motel and she assumed I was homeless, but I'm not homeless.
But originally, when I put you on probation,
I gave y'all 1825 17th Street, which is where I live.
if you had a residence here in Jefferson County and you were on probation here in Jefferson County, then why didn't you come back here when you got out like you were supposed to?
I tried to come back and I did come back. I didn't report because I thought I had a warrant out. I thought I was revoked already.
So you were just gonna wait it out until they came and caught you?
Came to turn myself in and I got arrested. I was gonna turn myself in.
Everything you're saying is conflicting. Because you're.
I'm here. I'm here.
Yeah, you're here in custody and you're just, I think you've told so many lies to everybody that you don't know how to keep up with them.
It's no lie, ma'am. I was in Houston. I came back and I came back March 7th. I was here. I didn't report. I was on drugs.
So you were already here March 7th?
I was here March 7th. I was here. And then she told me to come in.
So there's no reason on March 7th that you couldn't have, you were talking to her about needed a bus and all this stuff. That was all just lying back then.
No, I was in Harris County. I was in Harris County. I got here March 6th. She told me to report March 7th.
So if you were here March 7th?
Yes. Y'all know I was on drugs.
Our jail reports too, Judge.
Can you please give me the help that I need and let me keep my kids?
I put you on probation in the first place to get the help that you need. I put you on probation. Hang on. I put you on probation for 2 felonies with all the resources we have to help you. And instead of taking advantage of those, You came back, you didn't go ask for help, you just had to show up one time and say, I need help, I'm pregnant, I'm using drugs, I need help. It's easy to say you need help when you've picked up 3 more felonies.
I didn't pick them up, they dismissed them, I only got one. They dismissed the other ones.
Well, I'm sure that was part of some plea agreement. You still got arrested for
Yes,
3
ma'am.
felonies, serious felonies. Not just little stuff, not a possession case.
Your Honor, please, I do not want to be a felon. I can't complete
Well,
this.
quit committing felonies.
Yes, ma'am, that's because of the drugs. Then I lost a baby last year. I had a stillborn at 7 months pregnant because of drugs. I need help with the drugs and rehabilitation.
Maybe you need to stop getting pregnant for a while.
Yes, ma'am.
Looks like one of the jail incidents also involved an assault of another inmate and an attempted knock through a bar of soap and actually hit one of the correctional officers and tried to swing on one of the other correctional officers.
That is okay. I never tried to assault a correction officer at this time.
No?
Like jail, prison time, no.
Let me take a, So why did you refuse to go to the hospital when you fell?
Because I was feeling okay and I had a doctor's appointment coming up. I was gonna tell her. The last time I told them I slipped and fell, they didn't do anything in the jail, so I was gonna wait till I go to my doctor's appointment.
But they wanted you to go to the hospital to get checked out.
I didn't know they wanted me to go to the hospital. They just had me sitting in the infirmary.
So you supposedly said you fell, you were refusing to go to the hospital. They told you the doctor wanted you to go to the hospital. You said that you would go, but asked if you could go back to your dorm first. And they said, we're not doing all that back and forth. You asked if you would be transported via van or EMS. They said, don't worry about that. Then you said, I refuse, I'm not going to the hospital.
That's when I talked to Dr. Kim. Dr. Kim told me whatever was wrong, I could tell the doctor when I went to the doctor. So that's what I was waiting on.
So they're making it up that doctor wanted you to go to the hospital.
They wanted me to go, and I told them I was going to wait until.
So, but that makes me, you're not taking care of yourself and your baby.
My baby is fine.
How do you know? If you fell and hit your head and they wanted you to go get checked out at the hospital, then how do you know she's fine or he's fine? You don't know. I don't know what I'm gonna do. Go sit down for a minute. Mr. Rojas, you have Jacoby Chambers. Jody, do you know anything about Santa Maria? Is it locked down? I guess it's not if she left before. But nobody else will take her pregnant that we have, right? Give me just a second. Good morning. Are you Jacoby Chambers? And will your client waive the formal reading of the motion?
He will, Your
Mr. Chambers, in cause number 21-37015, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation September 14th of 2022 for the offense of aggravated assault, family violence, second-degree felony, and that was a 10-year deferred probation. Is that correct? This motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department February 12th, February 28th, April 8th, and May 8th of 2024. And how do you plead to that charge? I mean, is that true or not true? I'm sorry. And then count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true? Count 3 alleges that you provided a urine sample January 22nd and April 22nd of 2024 that tested positive for tetrahydrocannabinol. And is that true or not true? THC, marijuana. Is that true? Count 4 alleges that you failed to provide verification of performing your community service hours. And is that true or not true? Count 5 alleges that you failed to provide verification of entering and successfully completing the Battering Intervention and Prevention Program. Is that true or not true?
I have a certificate to complete that program.
Okay. Count 6 alleges that you failed to submit to alcohol or drug screening March 22nd of 2024. And is that true or not true? So it'd be not true. 2, 6. Count 7 alleges that you failed to provide verification of entering and successfully completing the moral recognition therapy, the MRT program. Is that true or not true?
I don't know, because she told me to complete the bill class first, and I complete the bill class.
Okay, so I'll put not true for 7.
I will start the other class, because that's the class you do at the parole building.
I'm not sure.
Yeah, I never start one of the classes.
Okay. Count 8 alleges you're behind in your court-assessed fees as of May 21st, 2024 in the amount of $225. And is that true or not true? Did you enter your pleas of true to counts 1, 3, 4, and 8 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? And do you fully understand them? And you understand if I follow the agreements you made with the district attorney, you'll be waiving or giving up any right to appeal. And the agreement that you've reached is for a cap of 5 years. So I can give you 5 years if I revoke your probation. I can give you less. It'll all depend on the information I receive at a sentencing hearing. Do you understand? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Chambers is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 3, 4, and 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do an updated report. That'll give me more information about you, your case, and then we'll come back for sentencing. All right, you can go back with the bailiff.
Okay, everybody, it's time to say goodbye, and I need to wrestle a cat who's getting playful all of a sudden. It's a good thing. Hope you all had fun today. I did. Not a weird day in court, which we've had a lot of lately, but a lot of heavier things, like in Judge West's court. She started out with a capital murder, so that's always a good sign, but we'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour early for channel members. Behind the scenes, a decision has just been made. We're going to take this week off from Sidebar and just kind of rejigger some things in the background to help us have really good content for you guys. So the show's not going anywhere. We're just going to put in some work behind the scenes and do that. So we'll be back with that next week, Tuesday. But just climb right up there, sweetheart. That would be fine. All right, so with a cat on my back, I'm going to get on with my day. You should do the same. Go make yourselves a great Tuesday. We'll see you tomorrow. In the meantime, take care. God bless.